Hi viewers, welcome to another video from @Newsworthy Publications. My name is Ben Gray. I'm an amateur journalist who's lived here in Bristol for the last 20 years, and this video, my YouTube channel is dedicated to exposing egregious corruption within the judiciary, both the High Court and the Circuit Judge and Magistrates Courts, the Avon Somerset Police and the Bristol CPS primarily. And this latest video is called Nothing to See Here, in brackets, merely attempted murder and other indictable offences, close brackets. This video surrounds an incident that happened on the 19th of September 2017 in a place called Cheltenham Road, which is near central Bristol, and it involves a near fatal collision whereby a driver by the name of Sabri Uzlati, who I later found out I didn't know and didn't think knew me, pulled out of stationary traffic, made a beeline straight for my bike as I was cycling past, and I'll show you the CCTV in a moment. He missed my rear wheel by a matter of inches. I had to avoid him by going onto the lowered pavement for the last stretch of the incident, and he then pulled into an open space which was one or two cars in front of him. I then confronted him, and he totally ignored me, laughed in my face effectively, and as I was maneuvering my bike around the back of his car, he tried to rear end me. He reversed his vehicle towards me, and I instinctively lashed out with a bike lock and dented his car before cycling off, and he gave chase. I had to confront him because he was about to catch up with me, and I threatened him with the bike lock so that he didn't attack me. He then marched back to his car, got into his car, and drove off. I asked him to remain, and before he drove off, he said he's going to kill me, and made death threats and shouted Allahu Akbar as he drove off. So there we have it, viewers. You can see that Uzlati, it was never properly investigated, so we don't really know his motives. On the face of it, it seems that he either deliberately pulled out to attack me. He saw me coming. He's presumably required to use his rear view mirror. I don't drive myself, so I'm not entirely 100% with the rules of traffic, but I'm fairly sure that vehicles, assuming he was allowed to pull out at all from his position, he would have been required to check his rearview mirror, side mirror, and he would have clearly seen me cycling just as he was pulling out, or cycling towards him before he pulled out. So he either saw me, used his mirror and saw me, and deliberately aimed his vehicle, pulled out to aim his vehicle straight at me. You can see the speed he's going. He's accelerating at dramatic speed. So that he's, even though I'm going reasonably fast, I would say about 25 miles an hour because it's a downhill slope, he pulls fast enough to catch up with me and just narrowly miss hitting my rear wheel. Of course, if he'd hit my wheel, the wheel would have immediately stopped dead, and my bike would have reversed, done a backflip probably, or he would have smashed me into the pavement and possibly run over me. So it was clearly he was playing with my life within inches of fatality. I could have easily had a child on the back. I have two children who used to cycle with me, used to cycle as passengers on my bike, so he could have included them in any fatality. And so clearly it was an absolutely terrifying and it seemed to me a deliberate act. On the alternative that he just didn't use his rearview mirror, all he wanted to do was save himself for some unknown reason. He was in such a hurry that he wanted to avoid the one car that was keeping him from the space in front of him. And as I understand it, I think the area has been painted over now, but as I understand it, the space that's left between the car in front of him and the car in front of that, which is the space he wanted to occupy and did occupy, is left free because that was actually for cars coming the other way to go into a side entrance to go into the slope, which is why there's a lowered pavement there. And if it wasn't for the lowered pavement, as I say, I wouldn't have been able to avoid Uslati in the first place. So it was clearly that he was occupying, as I understood it, a space that by law was being kept free so that oncoming traffic could turn right into the open space into the driveway. So in either case, it's either reckless attempted murder, GBH, or deliberate attempted murder, because he's driving in such a way that he very narrowly avoided killing me, and it was me that had to take evasive action. And if I hadn't done that, I think it was almost absolutely certain that the front of his car would have made contact with my bicycle to possibly lethal with possibly legal lethal repercussions. So far, so fairly straightforward. I of course, reported Uslati after he drove off. I told them about the dangerous driving, and I said that he'd made death threats before he'd driven off. I wasn't aware at the time, but as can clearly be seen, there was CCTV capturing the dangerous driving incident. And as it turned out, as we'll come to later, there was a man called Mr. Truslove, who worked as a garage mechanic in a quick fit garage that was just to the left of myself, where I'm cycling, and he was also a witness to Mr. Uslati nearly knocking me off my bike. But the 999 operators, of course, I've had dealings with most of them, the Avon Somerset Constabulary, because I've complained about other violent matters, including another dangerous driving incident in 2015, which we'll come to in due course, where I received this injury here. You can see it coming up on your screen now, where a man called Paul McGabeath, without any question in my mind, and as the evidence will show, deliberately drove into me on the wrong side of Hurlingham Road, which was just around the corner, as it turns out, from Cheltenham Road, and smashed straight into my vehicle. He knocked his own wing mirror off when he smashed into me, and the hinge of the wing from the wing mirror gouged a deep gash out of my leg, out of my thigh, which resulted in the injury you see there. But I'm jumping ahead because that was 2 years earlier at the time, and we'll go into more detail about that, of course. And both these matters were investigated, or had a part of the investigation was carried out by now what I understand to be an inspector or a superintendent, or he's a much more senior officer than he was when I dealt with him. As I've made clear in my other documentaries, any collusion in near fatalities against myself, armed assaults, perverting justice, perjury, anything of that matter is immediately awarded, or usually awarded, with a sudden bump in rank, as happened with Stuart Toms. But at the time he was a CID officer, a police sergeant for CID, and he investigated, or had a hand in investigating both matters. So we'll come to that and come to this in due course. But at the moment we're talking about the 999 calls. Um, I was just simply fobbed off by the 999 operators. I was told that it wasn't an emergency, even though there had been death threats, a near fatal incident from Mr. Uslati, and he threatened to get back at me. And of course, I've got some profile online, so he could have probably identified me quite easily. And I was told to effectively sling my hook. And I became more and more outraged by the treatment I was getting from 999 operators. And of course, as we've established with my other videos, for those that have watched them or intend to watch them, I'm subject to what's called a general civil restraint order, which means I cannot litigate the police or any other body by orders of, at the time, I think it was Lord Justice Warby, or Mr. Justice Warby as he was then. Of course, he'd been promoted. And which meant that any inaction from the police or collusion in criminality cannot be addressed through the courts through civil proceedings, because I'm banned from civil proceedings. Indeed, the general civil restraint order that bans me in this regard was brought by, yes, of course, you guessed it, Avon and Somerset Constabulary. So we see immediately the hand in glove a relationship between the police and, not in this case the CPS, although to some extent, because they've been involved in civil proceedings involving myself as well. But the police have simply got a fatwa from the High Court judges to collude in or themselves attack me whenever they feel like it, to however life-threatening, however it may involve other members of the public, as clearly Uslati's driving did. If they are the victim, as long as I'm in the firing line, as long as I'm the victim included in whatever savage attack has occurred or other criminal matters, Judge Warby and his other crony judges or colleague crony judges have imposed these orders that prevent me litigating and therefore effectively encouraging, on the one hand, they're encouraging attacks, encouraging abuse of power, abuse of office by the police to collude in the attacks or other kind of offences that undermine my rights or make me vulnerable to death or false imprisonment, you name it. And on the other, they're ensuring that any evidence of misconduct of that nature is not addressed through the courts. So, because I had no other option, and because this man had made death threats, and of course he was by, as you can see from the footage, dangerous by any criteria, I simply continued to call the police on the 999. They kept threatening to arrest me. I said, well, arrest me then, come to my house, you know where I live, and put the matter before the courts in that regard. And I made about I can't remember, but many calls to try and get the police to either arrest me, and therefore by those means I can put the matter before the courts. That's always my last recourse, is to be a defendant in criminal proceedings, because then at least I have some chance of going before a judiciary, an independent judiciary, and putting the criminality of the police and of course the CPS or whoever's involved, in this case Sabri Uslati, and so forth, and obviously plead self-defense and say, well, and duress, and say, well, my life was being threatened, and I have no other choice. But of course, as soon as I canvass those issues, I then have to bring in the issue of the JCRO and the fact that these High Court bigwigs like Judge Warby and at the moment Judge Davis, William Davis, who's another Lord Justice, who's increased the general civil restraint order to what's now called a civil proceedings order, which is even more draconian than the general civil proceedings order, which prevents me even bringing private prosecutions, for example. So these fatwas have now been in place for nearly 15 years. But of course, as soon as this comes into play in the lower courts, then of course whichever judge I'm in front of says, well, Judge Warby and Judge Davis and these other judges, who, in the case of Judge Warby, he actually chooses, he's involved in what's called the Judicial Appointments Commission, so he actually chooses which judges sit on the bench. So he is Mr. Puppeteer extraordinaire. I mean, he of course, any mention of his involvement and the fact that he's put the knife out for me and says he doesn't want me litigating and that he's called me everything under the sun. He says I'm a vexatious litigant and I make wild allegations and so on and so forth. That immediately prejudices whichever judge I'm in front of, and they want to fall in line with this Mr. Powerful nearly the most, I would argue, the most powerful judge in the country, because although the Lady Chief Justice, I think it's Baroness Carr, is currently is in theory the most senior judge on the bench, because she oversees, she's a lady judge in her own right, but she's the most senior judge who involves herself, who oversees all the other Lord and Lady Justices, as well as, of course, the lower court the lower ranking judges. But in the case of Judge Warby, as I've just mentioned, he's in charge of the Judicial Appointments Committee. So he in theory appoints. He has some involvement in Lady Justice Carr being appointed. So he is, arguably the most powerful judge in the country. And if he said I want, he's actually given an invitation in his judgments against me to say he invites any other judge who deals with me to be aware of his comments about what a paranoid and unreasonable troublemaker I am, and to be aware of all these issues before I've even gone in front of them. And of course, so this is what I mean, the extent of what I'm up against. But so the only way, as I say, is to go through, do everything that's reasonable and lawful within my understanding of the law to remedy whatever situation I'm in. So I deliberately continue calling on the 999, hoping in some respects that I would be arrested, and then I could argue why that this man Uslati is a danger and he needed to be locked up, and the police would not, of course, take a witness statement from me, which is all I was asking with my calls to the police. So that matter led to eventually my being pursued, not arrested, but I was asked for a voluntary interview because I was pursued for what they termed as malicious communications. Indeed, even before I'd made repeated calls to the police, my call, which seemed to be on the face of it perfectly reasonable, considering especially that it had happened in front of a CCTV camera, so there was no argument that it had occurred, it was being treated as a hoax call. The officers who had, the call handlers who had taken the reports from me about the dangerous driving and the threats to kill had, in what's called, I think, an ISR report document, noted down my call. They initially stated he had just had a male threaten his life following an almost RTC, road traffic collision, whereby the male, in fact, drove his car at him. So far, so truthful. That was my complaint. No mention of the death threat there, but it may be in some other part of the report. But thereafter, very shortly thereafter, the document reported my complaint as hoax. That was how I was being dealt with throughout. So, of course, the more I was being treated, so every other 999 operator I was speaking to, and presumably the police officers who were behind the scenes pulling the strings, were themselves documenting the matter as hoax and treating the matter as a hoax call. And of course, I forgot to mention that after the incident with Uslati, after Uslati drove off, I bumped into a man who I later was to understand was called Travis Baldwin. Now, Travis Baldwin, it turns out, was an American tourist or student who happened to witness the tail end of my altercation with Mr. Uslati, had seen Mr. Uslati get into his car and drive away after some heated exchanges between myself and him, and of course he had seen me with the bike lock. And Travis Baldwin had agreed, he'd taken photographs of some of the incident, which of course would have included the car details of Mr. Uslati, the license plate, and he agreed to take my email address and send me photographs of whatever he'd taken on his mobile camera of the altercation between myself and Mr. Uslati. So I received an email on the 13th of February 2018. So this was now many months after the incident on the 19th of September 17, from one Kerry Tottle. Now, from a detective constable from CID. Now, Kerry Tottle was the junior colleague of DS, Detective Sergeant. I think I called him PS earlier. He's a detective sergeant, sorry, from CID, of one Stuart Toms. who we'll come on to in a moment. But I had other dealings with him in the incident that I referred to at the beginning of this documentary, in respect to being driven, knocked off my bike by Paul McBeath. And Kerry Tottle wrote to me on the 3rd of February 18, emailing me, stating, "I'm emailing to request your attendance at police station as a voluntary attender. I would like to ask you questions under caution in relation to an offence under Section 127 of the Communications Act 2003. This offence relates to telephone calls made to the police 999 system on the 19th of September 20. So I think that's supposed to say 2017. So this is how things have progressed. They've refused to. The police have refused point blank to investigate. Well, as far as I was aware, there was some investigation into my own allegations, but as part of that, I was treated, in fact, as the culprit, and I was pursued for malicious communications in terms of what being treated even from the outset as hoax calls, and then the repeated nature of these calls was led to this investigation into myself for hoax calls. And I told Miss Tottle, I emailed her back promptly and said, I'm not slightest bit interested in attending the interview. If you want to charge me and I'll see you in court. And of course, that's exactly what they did, because they know they've got nothing but cronies on the bench well, where it initially started, certainly in the Bristol Magistrates Court, but all over it, because we know that any hearing I go in front of is immediately tainted and effectively overseen by the puppet master, Lord Justice Warby, or Mr. Justice Warby as he was, who has directed every single judge who is involved with me to be aware that I'm. This direction, of course, was by the police, the Chief Constable of the Avon Somerset Constabulary, paying huge amounts of public money to bring proceedings against me to bring about the general civil restraint order, somewhere in the region, when the dust settled, of £100,000. But this was the express view of Judge Warby, and the police and and of course by now the CPS know that they can cash this in any time they bring me before the courts. They can invoke the fact that the most powerful judge in the country, or arguably the most powerful country, or the second most powerful judge in the country, next to Lady Justice Carr, has put a marker on me to say, pursue Mr. Gray under all, he's made wild allegations against judges. He's paranoid and thinks everybody's against him, and he's totally unreasonable, and blah blah blah. And of course, this is exactly what the CPS and police rely on when they're investigating me for any matter. This is why, even though, as we've seen from the CCTV footage, which by now because Tottle is also involved in the investigation as to my initial complaints. So Tottle knows, and indeed we haven't come to it in detail, but there was the independent witness that was mentioned earlier, Truslove. So we've got the independent witness Truslove and the CCTV both proving that my allegations were utterly validated, that Uslati had driven at me at speed for no apparent reason, nearly killing me, and nearly certainly causing me serious injury. And they know this is so that my actual original allegations were completely verifiable, so that any suggestion I was making hoax or malicious calls was entirely fabricated. And they must know that at some point this is going to come before the courts, that the judge and the magistrates and the CPS, of course, would themselves also know, and will come to a particular CPS representative, a freelance barrister in due course. So that they are using the terror of this terrifying, dangerous, violent attack from Uslati as my response to that, as a justification to pursue me for effectively perverting justice, because the hoax call effectively is accusing me of making false allegations, that I'd fabricated this one of the most serious allegations it's possible to make, attempted murder against a poor innocent Mr. Uslati. And they pursued me. They eventually, and because I didn't attend the interview, charged me formally by post with the offence of malicious communication, and you can see the charge coming up on your screen there. So I was now being investigated, not just investigated, I was now being prosecuted for the hoax call, all originating from my reasonable complaint to the police that wouldn't have had to have been repeated through repeated calls if the police had simply said, yes, come and make a witness statement and we'll pursue Uslati and we'll investigate whether your complaint can be upheld. And Travis Baldwin's statement, the one that I received as part of the unused material, was dated the 29th of January 2018 and stated the following. I am Travis Baldwin and I live at the address shown over leaf. This statement concerns an incident that happened on the 19th of September 2017, which I witnessed on Cheltenham Road, Bristol, at about 4:15 p.m. I was walking along Cheltenham Road away from Bristol city centre towards the Cheltenham Arches with Quick Fit to my right, and I saw two men in the road and they were arguing. One of the men was holding a push bike in his left hand and had the D-lock in his right hand. He sounded very angry and was shouting with another man, obviously the other man being his latte. I will describe the bike man as follows, and with it's handwritten, as you can see on the screen, so it's a bit hard to read everything that he's saying. And we'll refer to him as male 1. White male, 35, 40 years old, which I'm very flattered by because at the time I was 50, I think. 6 foot tall, medium build, wearing trousers, long sleeve top and a backpack. He had a push bike in his left hand and was holding a D-lock with his right hand. The other male, who I later I think saw get into the driver's side of a car, was tanned complexion, but I didn't know him. I didn't know his ethnicity. About 30 years old, of similar height and build to male 1. I will refer to him as male 2. I know from taking, I think, or sending photos I took on my phone that the car registration was something YGW. The arguing between the two of them continued for a few minutes. It had been happening before I first saw them and continued as I walked by. I wasn't able to hear what exactly was being said, but I could tell that male 1 was definitely the more vocal of the two and was very angry about something. I noticed he had the D-lock in his right hand as he walked up to the car that male 1 got in. There was also a front seat passenger, but I didn't get a look at him. I started taking photos on my phone, and I was concerned an assault might happen. I produced these images, some incomprehensible numbers 1, 2, 3, and 4. I walked past the ongoing arguments, but then turned back a few minutes later as I wondered if the disagreement affected the cyclist. I saw that the car had driven off, but male 1, the cyclist, was still there. I told him I had taken photos and offered to send them to him electronically if he needed them. He was really angry and was keen to have the photos that I showed him on my phone. He said he wanted to email them himself, and then used my phone to call the police and the emergency mobile. I began to have concerns about this man, as he seemed to, I think they're supposed to be there, so he seemed to be acting over the top for the incident I had just witnessed. He was saying things to the police about jihad terrorist and Ali Akbar, which didn't fit with road rage that had just happened. He also said something about issues he had with police. I don't recall the exact words, but it was like the police are never going to believe me because they have got me for other stuff. To me, it all seemed, or something seemed disproportionate for what had just happened. He gave me uh, the phone back, and I continued on my way. I state, I sorry, I later had an email from him, and I know his name to be Benjamin Gray. I have never met him before or seen him since. Neither do I know the driver of the car or his passenger. It was clear, sunny afternoon. My view as I walked past was unobstructed, and at the nearest point, I would estimate I was 20 feet away from the car. In conversation with Mr. Gray, he was only a few feet apart, or we were, or something. My view of the incident was about 5 to 6 minutes long. I was taken, so it doesn't even make sense. My view of the incident was 5 to 6 minutes long. Well, he's said what he says. I was taken aback at the level of anger displayed by Mr. Gray and felt he may be a little unstable. The mobile number for my phone is and obviously that's blanked, which is the number Mr. Gray called the police on. I produced the email I exchanged with Mr. Gray as whatever that number is. As an independent witness, I initially wasn't sure who was responsible for starting or causing this incident. So that was the statement I received from Baldwin, which was obviously completely, chunks of it utterly fabricated in terms of our exchanges. We were extremely peaceful and passive, and of course, as anybody remotely sensible would understand, the first point I'd made is that Uslati had nearly killed me. It had been witnessed by an independent witness, as we'll come to, as I say, Mr. Truslove, and it can clearly be seen on the CTV that he had nearly knocked me square off my bike. For no apparent reason, when he had a completely empty space before and after I cycled past, and he chose the exact moment that as I was cycling past to move out of his stationary position and drive at my back wheel at speed and nearly kill me. And yet there's no mention in Mr. Baldwin's statement of the fact that he had nearly tried, that I complained, and my main reason for being upset with Uslati is that he had nearly tried to kill me. And then the Allahu Akbar was made in the context that he had made a threat to kill, and then said Allahu Akbar. So he was. It felt to me like a potentially deliberate driving form of a terrorist act, and of course that was why I was. One of the main reasons I was so anxious with the police wasn't simply that he'd made death threats against me, but that he'd shouted Allahu Akbar. He was clearly of Middle Eastern origin, as was eventually established by his surname. His name generally, and that he was therefore a danger to other people, and he was going to commit some other form of terrorist attack apart from just myself. But of course, Baldwin has completely. He's tried to incriminate me by saying that my response was over the top. Well, first of all, he also states in the incident, as you recall, that he didn't witness the original incident, so he doesn't know. He's witnessed the tail end of an incident, and then said my reaction to it because of my level of anger. He doesn't describe what I'm saying or doing about the level of anger. He even impugns my mental health, which apparently, I mean, surely if someone's nearly tried to kill me, then made death threats against me, and then driven off. And of course pursued me down the road. I didn't have the bike lock for as a sort of a present for him. The bike lock was the only way I'd actually stopped him physically attacking me, having chased me down the road. And he's bigger than me. Mr. Baldwin's not truthful about Uslati being the same height as me. He was considerably larger than me, and the only way to stop him actually attacking me was by threatening him with the bike lock. So I would have probably been it would have come across as more mentally unwell if I had been completely passive about this near-death experience and then violent attack and death threat from Uslati. If I just sort of said, the guy's just trying to kill me, but if I wondered if I could just have the photographs that he took of the incident, that would have been potentially more likely that I was mentally unwell than the fact that I'm upset about this man trying to kill me. But of course, I've engaged with Baldwin perfectly rationally about getting about what the incident was occurred, about why I needed the photographs and giving him some background, which of course Baldwin has deliberately whitewashed, which is again the clear modus operandi of the police, and we'll come to the police involvement in the statement obviously in a moment, but it is to whitewash any of the key evidence that supports a fatal attack or near, sorry, not a fatal attack because I'm still here telling you, but a near fatal attack or the main crux of any complaint I make is removed from the picture to then make me the culprit, to scapegoat me, and to get the pile in against me, rather than the actual the threat of danger from the individual in question. Of course, we have the Tesco incident. If anybody goes to my video for one example, or a very crystal clear example, Judge Martin Picton Must Fall. It's either part one or part two, but I go into the details. I think it's part one, where a man in 2008 had thrown a container of some description. I say a glass full of peanuts, but they say the police said it was a plastic container full of peanuts. But he threw it directly at my face. He missed my face. I ducked out of the way, and it smashed near children and elderly and other people behind me in a crowded Tesco supermarket in February 2008. So again, but yet I was the culprit. I was the aggressor. I was the person the police said had started everything, and was myself effectively treated as the criminal. When there's armed attack and innocent civilians were the target, and of course I could have been anybody in this driving incident. It just happened to be me, but of course it could have been Mr. Baldwin. It could have been the investigator, Stuart Toms. Could have been Kerry Tottle. It could have been anybody. So of course, and this was a major armed attack, just as the arm that I've been driven at in 2015, in January 2015, with the vehicle involving Paul McBeath. So as I was being forced to represent myself in terms of the malicious communication charge, I've been given this statement from Mr. Baldwin that clearly showed evidence that he had been coerced by the police or in some way persuaded to give a completely fabricated statement in terms of my conduct and the information I'd given him after the incident with Mr. Uslati. And I therefore used the email address that he himself had given me to contact him and ask him to what extent why he was giving such patently fabricated information in terms of a sworn witness statement. And of course, even the fact that I had his email address sort of undermined his assertion that my conduct was expressed some sort of mental health issues, and that I was over the top and so forth, because it seems that if I had sort of in any way been, to the extent that he was portraying in his statement, that kind of person, he wouldn't have given me his private email address. But in any event, I contacted him to try and make what I thought to be reasonable inquiries about his testimony. And I'll read out the email that I sent him and come back to some of the issues that I raise in it. Dear Mr. Baldwin, I apologise for troubling you, but I am a defendant in a prosecution brought by the police in respect to the incident to which you were a witness on Cheltenham Road, Bristol, on the 19th of September last year. I have read your witness statement carefully and am concerned and upset by the fact it is at variance with the truth on several points. Firstly, you claimed that my demeanour was over the top in respect to the incident that had just happened, in quotation marks, and indicated you thought I may be unstable. Of course, it is up to you what you tell the police in a sworn statement, but I recall we had a reasonably long and mostly calm chat for about 10 minutes. I recall you offering sympathy about dangerous drivers, and in particular you referred to a friend who had been severely injured by dangerous driving on Gloucester Road by police themselves. You made this point in agreement with me that police have an extremely lax attitude to dangerous driving. In your own statement, you accept that you did not see the driving complained of that began the argument, and you surely were intelligent enough to deduce that the man had not left his car parked in the middle of a busy road and followed me a good 50 feet in order to exchange pleasantries. I also told you that he nearly killed me twice, as would be clear in the 999 recording of the phone call to the police you let me make on your phone while stood next to you. Yet you make no mention of the alleged attempted murder or threat to kill from male 2. That's Oslati, obviously. Consequently, you seem to have deliberately whitewashed my complaint that I had minutes before nearly been killed by dangerous driving from the male. CCTV captures the dangerous driver and police accept it was dangerous, and then accuse me of being over the top and unstable because I responded in a way that you felt disproportionate without uh, that should be indicating what you said or did. What I said or did to justify this accusation. I referred to Alu Akbar, quoting from the Mail, that had nearly killed me, yet you put this as if I had just randomly said those words for no particular reason. As I say, it is entirely up to you if you want to portray me in the worst possible light by making misleading and untrue statement, by making supposed to be a misleading and untrue statement to the police about my conduct, and falsely accused me of being over the top in response to an incident that you did not even see, whilst whitewashing the violent, potentially lethal trauma I had just endured at the hands of the driver. However, I am concerned that you were intimidated or in some way bribed or coerced into making such a clearly false and prejudiced sworn statement to the police, not least because you did seem sympathetic and showed solidarity, both through the photos and 99 call and in regards to your similar story about dangerous driving from the police themselves. Please let me know if my concerns that you were coerced, or in general why on earth you have given such a plainly spun version of the incident that you partly witnessed, are justified, and whether you accept that your statement to the police was both misleading and, in particular, you have deliberately left out what my grievance was with Mail 2 in your statement in order to justify the plainly untrue statement that I was over the top in my reaction to nearly being killed a few feet from a busy school. If I haven't heard back from you by the end of next week of the response to the above, I will make a formal complaint to the police that A, you made the statement without any influence one way or the other from the police, and B, have therefore perverted public justice by making a false witness statement. Please note that I have the right to ask the court to call you as a witness if you refuse to give evidence in my defence, and will consider my options once you clarify why, that's supposed to be you, gave such a patently false version of our meeting on the 19th of September 17. Finally, please note that the inspector who led the investigation into the driving matter is himself currently subject to a PSD investigation. I look forward to any feedback you may have. Yours sincerely, Ben Gray. So that seems to me a perfectly reasonable line in inquiry that any defence solicitor would have made on my behalf if I had been represented, and I was entitled to make on my own behalf as I wasn't represented. The issue at the end as to referring him to the police for perverting justice and perjury, or certainly perverting justice, was clearly what I was entitled to do if Mr. Baldwin hadn't properly explained or hadn't indicated that the reason he gave the full statement, which in my view stands, was because he was coerced by the investigating officers. And as we should come to in due course, the investigation into both my allegations against Oslati and the investigation into me for the hoax call was directed by Stuart Toms, and I'll come into more details about that investigation in due course. Bearing in mind that Stuart Toms, as I've already mentioned, was also involved in the cover-up of evidence of collusion in an attempted murder, which included by Judge Horton of Bristol Crown Court in 2015. So there is clear overlap and what's known as modus operandi, that is the way of dealing, the usual methods used by the police in terms of not just the police but the judiciary, which of course is the main object of my documentaries, and it concerns them because all this corruption is spearheaded by the judiciary rather than the police. The police simply know that they have the judiciary in their pockets, and vice versa. The police have the judiciary have the police in their pockets, and it's a nice, cosy relationship. But enough of that. The next witness statement I'm going to read out is from Mr. Oslati himself. Now, his name is Sabri Oslati, his full name is, and the statement that is dated the 3rd of January 2017. That's clearly a mistake. And it shows you the degree of absolute how useless the police are in terms of gathering evidence and taking sworn witness statements, because of course the incident happened at the end of 2017, or towards the end in September 17. So of course, unless as you know, I've already said there's some evidence that Sabri Azlati did deliberately gun for me personally. I mean, obviously it would have been quite convoluted for him to have made such a to have known that it was me coming down the road at that speed at that time. So it's unlikely that he specifically gunned for me. But if he had, then it would make more sense that he'd made the statement, this fabricated statement, sort of 9 months before the incident had actually occurred. But he's obviously, presumably, it's obviously 3rd of January 2018 that he made the statement. And I'll read out as best I can the statement from Mr. Azlati. I live at the address Overleaf. I am the owner of a silver-coloured 4-door saloon Volvo, something regulations, which and the obviously the registration. The registration is of course redacted, which I purchased in June 2017. Sometime after 4 p.m. on Tuesday, the 19th of September 2017. I was driving my car along Cheltenham Road towards the city centre. I had in my vehicle at that time a James Kimu, I can't read that, that's unreadable again, a something was sitting in the front near side passenger seat of my vehicle. I was approaching the traffic lights opposite Quick Fit garage and was slowing down my vehicle and driving at less than 10 miles an hour, yes, to stop at the lights, in brackets traffic, as they were showing red. As I was doing this, I saw in my rear view a pedal cyclist who was cycling at speed in the same direction as me. I was about 10 meters away from I think if I say the traffic lights at that time, brackets, about 2 car length away from traffic lights, close brackets. This cyclist cycled past me very close to my vehicle, about a meter away from me. I then stopped by the traffic lights and saw the male of the bicycle first throw his bicycle he was riding onto the road and approached me in my vehicle. This man looked very angry as he approached me. I decided to get out of my vehicle after turning my vehicle engine off and putting the indicators on to see why the man was so angry. I approached this man or male, and he said to me, "Motherfucking cunt. You shouldn't be in the country," quotation marks. I said to this male, "I'm sorry if I something you any harm. I didn't touch you. We had 1 meter of space between me and my car." This male went to the rear of my car, still shouting and swearing at me. I cannot remember exactly what he said. He had in his right hand a metal U-shaped padlock with a bar across it. I was concerned what he was going to do with it. I then saw the male with some force hit the rear near side boot area of my car once with the padlock he was holding. He hit the once, causing a dent. I then went over to him and asked him why he had damaged my car. Something started insulting me and swearing. He mentioned again "fucking cunt" and other swear words. He also said I was lucky that he didn't hit me with his padlock instead of my car. I said to him that he was a horrible person and I was concerned that he was going to hit me. This male continued swearing at me and still had this padlock in his hand. I was so concerned for my safety, I returned to my car and decided to drive off. The lights at this point had changed to green. As I drove off, I saw the male swing the padlock towards the rear of my vehicle. As I drove off, he just missed hitting my car and was stood in the road shouting and swearing at me with his arms raised and the bike still in his right hand. I saw all of this through my mirror and my wing mirror. I just didn't know what to do and drove off and didn't report the matter. At that time, I had other issues in my mind and just did not want to get involved in making any complaint. At that time, this incident happened, it was daylight and a clear day. I had good visibility, which was not obstructed. The male in the pedal cycle I would describe as white male, about 40 years old, 1.9 meters tall, big built, clean shaven, with a lot of stubble. A bit of stubble. Well, if you're clean shaven, then there's no stubble, but never mind. I can't remember something almost his hair. I can't read the rest of that, but it's largely irrelevant because it's obviously the first part of the statement that I'm most concerned about, and I hope you are too, because that's obviously, we've got the CCTV. Bearing in mind this statement was made 3 months after the incident, so it's September, October, November, December, so it's more than 3 months after the incident had occurred. The police had long since obtained the CCTV footage, as they themselves accepted. There was an independent witness, as I'll come to in due course, by Truslove, and yet the police have quite unbelievably, although perhaps not in the context if you've watched all my other videos, true to form, they have just simply permitted Mr. Uslati to make the most brazenly perjured criminal statement or witness statement that is possible to imagine, because he was not stationary in the traffic queue, minding his own business when I slowed down beside him, threw my bike on the floor, and went over to bombard him with abuse and accuse him of whatever, or sort of simply abuse him, which was Mr. Uslati's statement. Mr. Uslati can clearly be seen on the footage, and I'll just show the key moments just for clarity. Pulling out when I'm cycling past him. I would have been past him in a few seconds. So, assuming that he was in such a hurry to get one place further in the queue of the traffic, this was his main objective, and if he killed somebody in the process, so he, again, just to recap, he either didn't look at his wing mirror or saw the wing mirror, saw me coming, and didn't care that he was going to nearly kill me and drive into me as he pulled out. And whichever way it was, it certainly wasn't him being stationary in his traffic and me, for no apparent reason, first of all abusing him and then bombarding him with racial abuse and telling him and effing and blinding. I never eff and blind, even in heated situations, in any case. But he says I did this for no good reason at all, for this poor man that was just sitting in his car. And of course, I've got a photo of Mr. Uslati here, because you'll remember that he's described by Baldwin as being Middle Eastern looking, and he claims that before I'd spoken to him and engaged with him at all, that I knew he was Middle Eastern. He doesn't look Middle Eastern at all. He's not brown skinned. He's not Asian looking in any description. There's no way that if I was just passing, or even passed him on the street and had quite a close look at him, would know instantly that he was Middle Eastern or of that kind of descent. He looks Caucasian as far as I can tell, and I'm sure you can agree that was the case. So I would have had to have known that he was a foreigner without having spoken to him or exchanged words with him, or him being, in fact, probably during the summer months, I'm probably browner than he is, because I catch the sun quite easily, and in any event, the key point, without wishing to deviate too strongly from the key point, is that it's complete perjury. The dispute between myself and him, whatever he later claimed I'd said to him, was about his dangerous driving that clearly nearly killed me, for which there was a witness and for which was captured on CCTV. And yet the police have simply taken down this statement, and then of course they're not using it. They're going through the motions of investigating me for the dent to the car. This is why they've taken a statement from him at all. So that was going to be included. There was some idea that they were going to do me for hitting his vehicle and or criminal damage to his vehicle. Potentially, obviously, with the racially aggravated element, with the "fuck off at your own country" statement from Uslati. But of course, they knew at the time that there was not going to be any prosecution, because they knew at the time that Uslati was guilty by their own admission. There is a statement from DC Kerry Tottle, who was who got all the statements and collated all the what's called unused material, which included the statement, because I got the statement as part of the disclosure when I was being prosecuted for the malicious communication with Baldwin. And just for those that don't know, unused material is material that may undermine the prosecution's case or improve the defence case in whatever proceedings are occurring. It's something that's not relied on by the CPS. They're not intending to call Uslati or produce his witness statement, but they are obliged under the rules. And this is how lunatic and brazenly corrupt the CPS are in terms of knowing that they've got the judiciary in their pockets, because they're complying to the letter with their obligations to disclose material that undermines their case or helps my case helps my case. And the unused material in this case is glaring evidence of perjury under the Perjury Act, and certainly perverting justice by making false allegations. When they've already disclosed to me and are going to be relying on, presumably, the CCTV footage, or maybe actually I think that was unused material as well, but they've provided the CCTV footage that proves that Uslati had nearly tried to kill me and therefore was already guilty of dangerous driving, if not attempted murder at GBH. And then to add insult to injury, they then rely on Uslati's sworn witness statement. Well, they don't rely on it. They provided me with the sworn witness statement. So they provide this bundle of evidence that the police and the CPS and Uslati have colluded in the most serious indictable criminal offences, almost on the statute, on the law books, in order to pursue me for what's a summary offence, malicious communication under whatever it is, section 134 of the whatever act it is. I'll bring it up on the screen as I'm speaking now. But it's the maximum sentence is 6 months. It's not an indictable offence. So in order to pursue me and to build a case against me and to pursue it all the way into court, which is what they did do, all the way to trial in the magistrates' court, and then eventually 2 years later actually in the criminal courts, where it was dismissed by the judge, whose name hopefully I can find before the end of this documentary, but the judge dismissed it as no case to answer, on the basis that I was making too many 999 calls, and the 99 calls became heated, and I used words that weren't pleasant. I can't remember exactly what words. I may come to it, but it's largely irrelevant, because it was in the context that the police were colluding in this brazen attack by Uslati, with a virtually armed attack. So that's merely some of the evidence we have of the extent to which the police might just as well have been, indeed the judiciary, as it turns out, and the CPS might have just as well been paying for Uslati to nearly kill me with the vehicle and then perjure himself stupid. For all I know, money did change hands. It wouldn't surprise me, but that is the extent of collusion. And of course, as a sort of a side point, which you're probably aware of anyway, this has all been done on the taxpayer's dollar. The taxpayer is forking out thousands and thousands of pounds in this investigation and then in the prosecution, which was clearly doomed to failure, even with the biggest crony, around. They were unlikely even then to secure a conviction for the hoax calls or the malicious communication charge. But then all this extra material that they've gathered and the statements that they've obtained, there's another statement from Baldwin, etc., is all costing the taxpayer thousands and thousands of pounds in order for them to collude in this absolutely brazen these criminal offences carried out by Uslati and then the investigating police officers. So the malicious communication charge, the main witness for that allegation was someone called Rob Simons, and Robert Simons, who gave a statement dated the 9th of November 2017. So this is in connection with DC Tottle and DS Stuart Toms' investigation into me for the malicious communication, and they're predicating their basis on this mainly from the statement of Robert Simmons. So I'll read out the statement and then we'll come back to what the implications of this statement. I am police staff member 6934 Rob Simons of Avon and Somerset Constabulary. I currently work as a communications manager based in the communications department at police headquarters Portishead. Part of my role is to manage and oversee calls coming in to call handlers. I put this into context. Avon and Somerset Police on average take approximately 2,500 calls per day. 600 of these will be 999 calls. We estimate that 1 in 5 999 calls are not genuine emergencies. Aside from those people who may be misinformed about whether to dial 101 or 999, there are an increasing number of people who are choosing to abuse the 999 and 101 system. I have been made aware of a male called Ben Gray. Ben lives at 6 Boswell Street, Bristol. Ben uses the number, it's not my number anymore, so I don't mind it going on the screen, to make calls to the police. There are 17 calls recorded on the 999 telephone system from Ben. He calls me Ben. Of course, this is to... I detest. I think I mentioned it probably in most of my 999 calls. So Simmons is aware that I detest being called by my first name by strangers, especially police officers or in official capacity, because it's immediately to remove your dignity, remove your status, effectively treat you as the village idiot. When of course when you're actually in a courtroom, the judge and the CPS and so forth, even if you're the defendant, they call you Mr. So and so. They don't start calling you by your first name. In an official criminal investigation of any description, you usually refer to them as Mr. or Miss or Mrs. You don't refer to them by their first name, especially if this man is trying to bolster a prosecution based, as we shall see, on the most corrupt collusion in the attack by Uslati. But so just to stress, I don't like being called Ben, and it's deliberately being used because they know I don't like it. It's actually a form, ironically, of malicious communication and certainly harassment. In any way, Ben lives at 6 Boswell Street. Well, my address is all over my website, my YouTube channel videos, so I'm not going to redact that or cover that up. There are 17 calls recorded on the 999 telephone system from Ben on the 19th of September 2017 between 15:34 and 18:39. During the calls to police, Ben did not disclose a genuine emergency but was repeatedly asked to call 101. There are no recorded calls on the 101 system from Ben on the 19th of September. All calls into the police communications centre are recorded and can be exhibited and listened to for evidential purposes. It is clear that these calls have taken up and continue to take up valuable time that could be spent answering other calls with a genuine emergency or police need. The total time call handling staff spent handling calls from Ben on the 19th of September is approximately 47 minutes. To put that in perspective, currently an average 999 call takes 8 minutes to handle, and average 101 call 11 minutes to handle. With recent budget cuts, our police communications centre at this time struggles to meet the demand placed upon us by members of public calling both the 999 and 101. Our predictive analytics system predicated 78 999 calls and 208 101 calls between 15:30 and 19:30 on the 19th of September. We actually received 103 999 calls and 208 101 calls during this period. During this time, only 86% of 999 calls were answered within 10 seconds, which is below our target of 90%. With call handlers and supervisors committed to dealing with Ben, it only makes it more likely that we are unable to answer a call from somebody having a genuine emergency or with a genuine need for service on 101. So there's not a single shred of detail about what I'm calling about and why it's not an emergency and why I'm repeatedly making the calls, all of which was explained in every single call I made. I'm not going to play them now. It would take too long to find them on my system, and there's no need to play them because there's no dispute I made. Certainly, I don't dispute most of what, if not all of what Mr. Simmons says, except whether it was a genuine emergency and the fact that how the police were dealing with it. If they wanted it for a kick-off, I've already explained that Uslati had made threats to kill, so there was an ongoing threat that he was going to, or threat to me, fear of life, that he was going to carry out the threat to kill. And secondly, that he was clearly a dangerous driver and could well have been, for all I know, a terrorist, because his driving at me appeared to be an act of terrorism. And as it became apparent when I spoke to him or engaged with him, and certainly from his statement, that he was a Middle Eastern extraction, and obviously that would heighten the likelihood of it being some form of terrorist attack, and therefore the likelihood that he was, if not a terrorist or a potential terrorist, he was a dangerous driver that was going to, or at some point likely to commit the same kind of dangerous driving, and actually his vehicle was going to sooner or later make contact with a cyclist or a pedestrian or another driver or a motorcyclist. And for that reason, obviously there was an ongoing emergency situation that put me in fear and other people in danger. And secondly, of course, there's no mention from Simmons that all I was asking for was some feedback from the police. I'd given in my first call, the call that I'd made on Baldwin's mobile phone, because I didn't have my phone on me at the time of the incident, saying, please don't call me because things generally get heated with the police because of my history with them, including 4 or 5 false imprisonments at their hands and assaults. In order to not to escalate things as they did escalate with the police to the extent of my being prosecuted at, probably at the end of when the dust settled, 30 or 40,000 pounds of public money in pursuing me, indeed, because the perverting justice charge, the indictment, grew out of the malicious communication charge, which itself grew out of the failure of the police to respond to the 999 call, then if you add those two cases together, and I was remanded for some period of time in custody by Judge Tracy Lloyd-Clarke, currently the resident judge of Bristol, and again she's been promoted since I dealt with her. So again, we see the history of promotion of judges. And of course, it's worth pointing out that Tracy Lloyd-Clarke is now in the headline newspapers because she's there was a rapist. It'll come up on the screen now. The headline on this: there was a man convicted of raping a child, a 14-year-old, who was only given 2-month sentence. In any event, so he would have done a month of that. And then being released for raping a 14-year-old. But Judge Tracy Lloyd-Clarke gave me, I think I ended up doing the equivalent of a 3-month prison sentence, if not more, when she remanded me without bail on the perverting justice charge, which which should never have been brought, as I hope this documentary has made clear. And in any event, the CPS offered no evidence. And Tracy Lloyd-Clarke's main reason for refusing me bail was the strength of the evidence against me, evidence which the CPS admitted they didn't have any of when the actual day of trial on the 4th of September 19 occurred. So the dynamic and the way the corruption in one case feeds into corruption in other cases, and then once the judiciary get their corrupt hands on it, or some elements of the judiciary, in particular those connected to Albion Chambers, as I've made clear from other documentaries, either Albion Chambers or 2KBW Chambers, and of course Cardiff Crown Court, where I was remanded by Tracy Lloyd-Clarke, and where she's now the resident of that building, is stuffed with Albion Chambers judges and barristers, and it should never have gone there because there was even a ruling by Judge Dingemans, who's a High Court judge, who said that the case should go to London and not Cardiff because of conflict of interest with my history with Albion Chambers. So it just shows you the extent to which you have one little bit of corruption, or what seems to be corruption about one person or one individual, and that just bleeds in and feeds into every single other part of the judicial system or the criminal justice system. And you have the icing on the cake that this clearly venal and wicked Judge Tracy Lloyd-Clarke, because she would have had all this evidence of corruption, all the video of the CCTV of the near fatal attack from Uslati, the sworn perjury from Uslati, all of which I'd highlighted to the judge at a hearing before her, the patent fabrication, all of that predicated on and the prosecution against me based on that email that I read out earlier, claiming that that I said I would refer him to the police if he hadn't explained or hadn't indicated that he was coerced, was allegedly perverting public justice. But anyway, returning to the Simmons statement, the other element obviously was all the police had to do was contact me, and no mention of made to Simmons of the fact that all the police, if they didn't want me to continue with the 999 call, then I needed some assurance that the police were going to take Uslati in hand and simply contact me to assure me that a statement was going to be made. And even if they'd called me against my wishes to be called, then that would have been better than them simply blanking me. But I certainly didn't receive the email, which is all I was requiring, with a date and time that I could attend the police station or meet up with the police to give a sworn statement against Uslati. And of course, I was never allowed to make any statement against Uslati or against anybody else in relation to these proceedings. Indeed, Uslati was the one who got to make a sworn statement, even when the police knew every word coming out of Uslati's mouth virtually was fabrication, because they had the CCTV proving his description of how we engaged to be utterly made up and ironically perverting justice by making false allegations and concealing the commission of an offence. Here's another chief architect of all this skullduggery. This is James Wasiak. James Wasiak is the inspector who was overseeing. So he was behind the scenes during my so-called Hope's calls about Uslati, and he was the main reason, as he makes clear in a statement that's dated the 2nd of August 2018. So this is now nearly a year after the incident. James Wasiak makes the following statement, and then of course we'll come back to analyse that a bit. I am Police Inspector James Wasiak, 4347 of the Avon Somerset Constabulary, currently based at Police HQ. I am responsible for overseeing investigations within the Incident Assessment Unit. The unit conducts initial desk-based investigations into lower-risk crimes until a decision can be made to either file the investigation or interview a suspect. I am making the statement in relation to my supervision of Crime Report 52-17-214-393 made by Mr. Benjamin Gray. My notes on the investigation are contained electronically on the Crime Report. On Monday, the 16th of October 2017, I was asked by PC Carpenter for advice on the above investigation. She explained that Mr. Gray had made a complaint around her handling of the case that was unclear on whether she could continue to investigate it. So this apparently is, just to clarify, this PC Carpenter was supposedly investigating my complaint about the dangerous driving against Uslati. She said, this is October 2017, so this is now a month, or 16th of October, so nearly a month after the incident itself. So if he had been a dangerous driver, it would have been a bit late to start investigating the potential that Mr. Uslati is running around trying to drive people off, trying to drive into people and potentially kill them. I spoke with Richard Budd, Professional Standards. Well, here's a photo of Richard Budd. Richard Budd is, if you go to my other YouTube channel videos, the Newsworthy Publication videos, you will see that Richard Budd is involved in every single complaint, has been since I think about 2015 or so, certainly for the last nearly a decade. He deals with every single complaint. He just simply lies his head off. But in any event, I spoke with Richard Budd, Professional Standards, by telephone, this is Wasiak speaking, to understand the nature of the complaint and whether there was a specific instruction from him to appoint a new officer in the case. I was advised the decision lay with me. Having considered the complaint, it did not appear to me that PC Carpenter had acted anything other than properly. I determined that changing the IOC was likely only to result in complaint about a further officer and that PC Carpenter could continue the investigation. I updated Carpenter with my decision and she briefed me on the investigation to date. I would likely have provided some verbal advice, but as the CCTV was not working at this point, I suggested we review the investigation more thoroughly once working. And of course, that's just another. If you go to go to my video documentaries, both the ones that are currently online and ones that I'll be making online in the future, the amount of not working CCTV cameras or CCTV discs, etc., is mind-boggling. It goes into double figures in terms of even in the last sort of 10 or 15 years. Every time somebody attacks me, every time especially if there's a dangerous vehicle involved or some other form of use of torture instruments like the handcuffs, CCTV cameras are inoperative. Anyway, at this point, or cameras or players or whatever it is, at this point, efforts have been made to obtain a witness statement from Mr. Gray without success. No effort was made to take a witness statement. It's complete and utter fabrication. I think I do recall vaguely I sort of missed a 999 call not a 999 call, a voicemail message from Carpenter, which I tried to return, chased her up, but to no avail. But of course, the idea that they couldn't have the sentence at this point, efforts had been made to obtain a witness statement from Mr. Gray without success. What efforts aren't indicated? Why? There's no indication that I refused to give a witness statement, etc., etc. But anyway, on the 18th of October, I viewed the footage with PC Carpenter. In summary, I determined that given contradictions between the available evidence and Mr. Gray's initial account, there was no prospect of conviction with Mr. Gray as complainant, in brackets. I advised that no further inquiries were conducted and the matter filed. On the 20th of October, I recorded this decision and the full reasoning of the crime on the crime report. I provided the same reasoning to Richard Budd for this update and had no further dealings with either the investigation or complaint. So, to begin with, we look at what Mr. Wasiak states initially. The unit conducts initial desk-based investigations into lower risk crimes. So, when I was investigated for the malicious communication, which is a low risk crime because you heard Mr. Simmons's statement in which all he's complaining about is that I've made too many 999 calls. He doesn't say what the allegations I made were and why there was what I was complaining about in terms of response from the police. But at the very worst, it was a low level complaint in which maybe I was hogging the 999 calls up. Which of course may be kind of putting people at risk, but it's not on the scale of trying to kill somebody in a vehicle with deliberate intent. So why is Inspector Wasiak involved at all? Because it's not a low. I was complaining about attempted murder. There's no dispute, although Simmons doesn't include it. That was clearly the basis that we'll come to. There's no dispute that was what I was complaining about. So it shouldn't be investigated by a low or overseen by a low risk inspector anyway. And yet, when my complaint the complaint against me for malicious communication is investigated by CID, who are supposed to deal usually with the most serious type of offences or alleged offences. But of course, what he says in terms of my contradiction. Well, what contradiction? What do I Where does Wasiak? He's accusing me. If it was contradicted by the CCTV, then what should have happened to Uslati should have happened to me, because clearly I'm perverting justice. Indeed, the whole basis of the Hope's Call issue was simply that I've made too many. Well, you can see you've seen the record from the IRS report, which is when the initial call handler about the dangerous driving complaint had been made, where it's already treated as a hoax call. It's treated as a hoax call on the very day that I make the allegation. So it wouldn't have mattered how many times I'd made the call. What should have been of far more serious concern to the police was the fact that I was perverting justice by making false allegations, or at the very least, wasting police time by making false allegations. If Uslati had done nothing wrong, let alone if I'd acted in the way he alleged rather than I was alleging, then obviously I should have been pursued for making false allegations. And if I repeated them under oath, which I never got to do because I never gave evidence because the case was thrown out before I gave evidence. But in any event, just simply making false allegations. Here's the authority on the screen now to put somebody at risk being investigated on a concocted story is an indictable criminal offence carrying up to life in prison. So Wasiak is accusing me of perverting justice. If there were so many such glaring contradictions that he had to close down the case because he'd finally seen the CCTV footage, which he didn't see until a month later, and of course. At what stage was the CCTV viewed? Because it clearly wasn't viewed at the time. In any event, my call was being treated as hoax, which was on the day. So the CCTV would have been seized quite a considerable period after the time my calls were already being treated as a hoax, as hoax calls. And then, of course, in order for there to be no repercussions for the 99 operator that was marking my complaint down as hoax, I think probably involving a police officer at some stage. Involved in that hoax call, but certainly the operator. And yet, if Wasiak had viewed the CCTV and told the truth, namely that the CCTV fully supported the dangerous driving incident, then of course certainly that 999 call handler should have been before the courts for perverting justice by lying and fabricating as they did do, fabricating the report. So every officer has to come in after the fact and then fall in line with the hoax call complaint. And yet, of course, I wasn't pursued for perverting justice. I was pursued for perverting justice, but not in relation to any suggestion that I had fabricated the dangerous driving allegation against Islati. And of course, Wasiak doesn't say, he should be saying, giving some indication of where my story differs from the version of events given by me, but he doesn't, because he knows he can't, because he doesn't even say what's on the footage. And we can see the footage. The footage clearly shows the dangerous driving. And of course, by this time, certainly by the time this statement has been gathered up by the CPS and the CID, the head of the investigation into me for the malicious communication, it would have been aware to DS Toms and to the CPS that the CCTV fully supported my version of events, and therefore Wasiak is lying in his teeth. He's perverting justice to conceal the commission of an offence, and of course to bolster the allegation that my calls were hoax, which he couldn't, as I say, he couldn't possibly have known at the time. Nobody could have known at the time until they'd viewed the footage, which in any event proved my version of events. And of course, again, by the time Wasiak has given his statement, which is nearly a year later, the beginning of 2018, Sabri Lati had already provided his witness statement, which is by any definition completely fabricated, because he doesn't even say that he pulled out of the queue and nearly drove into me, and that was the incident that sparked my engaging with him. And of course, even if you ignore the CCTV, we have Truslove, who again had given evidence, and I'll come to him now. He had already given evidence that he had seen the silver vehicle nearly knock me off my bike, and yet Wasiak, without even blinking, without even missing a beat, and he was actually to come in to give evidence before a district judge, Harms. But Wasiak came in to give evidence about this matter in the Cardiff Magistrates Court. And District Judge Harms he said, he allowed this perjury. He'd seen the CCTV footage. He knew that Wasiak was lying in his teeth, and allowed Wasiak to even bolster and further incriminate himself by lying in his teeth to say that the footage showed that my version of events was not credible. And of course, as I say, we've seen the CCTV footage, so we don't really need further evidence. But just to sort of dot all the T's and I's and cross the T's and dot the I's, we have this unused material of the records that are the list of unused material that includes brief details about what material is in question, provided again by the police, collated by Kerry Tottle, who's the CID officer that's pursuing me for the malicious communication. And of course, this would have been overseen by Stuart Toms, because he was the senior officer in charge of everything. And she gave this information in the unused material police schedule of relevant non-sensitive unused material. She states that niche report 5217214393, initial report made by Mr. Gray of assault. Niche report documents the inquiries made by the investigating officer PC Carpenter, and remember she's mentioned by Wasiak, and subsequent review and authority to file it by Inspector Wasiak. Niche also makes mention of witness Mr. Truslove. So this makes it clear that the Wasiak was aware of Truslove's independent testimony, and we'll read that in a moment. But just to make it clear that this has been also provided and is not even mentioned in Wasiak's reason for filing and dismissing my allegation of the attack from Uslati. And subsequent review and authority to file it by Inspector Wasiak. Niche also makes mention of a witness, Mr. Truslove, or Love, who was working as at the quick garage at the time and was spoken to by police, who stated he saw a silver car, unknown make, model, in traffic. The car before it had left a gap, so people can get into. Sorry, the car before it had left a gap, so people can get into a nearby driveway. The silver car swerved out of the lane it was in, into the bus lane, and then into the gap that had been left. As the car was doing this, it nearly hit a cyclist that was riding by. The cyclist then swerved around and went back to the silver car, to the driver's window. The cyclist was shouting. The cyclist then swerved around and went back into the silver car to the driver's window. The cyclist was shouting at him things such as "You could have hit a kid," etc. So no evidence there of shouting racial abuse, as Latty had claimed, but more importantly, the key words are the car was doing this. As the car was doing this, it nearly hit a cyclist and was riding by. So the very same complaint that I'd initially made in the repeated 999 calls was supported both by the CTV and by the independent witness Truslove, and that evidence was collated by Carpenter and put in front of. By the time Wasiak was reviewing it a month later in October, he had in front of him not only the CCTV, which Wasiak claimed to have reviewed, but an independent witness. So he's not only accusing me of fabricating the near death, the near collision, and therefore near fatal collision incident with the vehicle. But of course, he's effectively accusing Truslove of making this up as well, even though I didn't know him from Adam. I didn't even know he'd given evidence and provided this evidence until years later, or certainly a year later. And so that is just statement after statement after statement of barefaced, evil, perjured evidence, all to cover, all for this one incident. Obviously, the public justice, the public issue about this dangerous driver. The whole point about pursuing dangerous drivers is that so that the roads are a safer place. Even if it had been words of advice or some kind of reprimand, then some good would have come out of him nearly killing me. But instead of the police just doing the right thing, the vendetta against me and the knowledge that they have the judiciary in their pockets is in fact to spend God knows how many tens of thousands of pounds of public money collating perjured evidence, getting evidence from officers, and every time a police officer perjures themselves and perverts justice and conceals the commission of an offence, or get some innocent person stitched up, it obviously completely destroys the trust in the public justice system. But by this time, I've now because of my email to Baldwin, I'm now. The CID are now onto me for perverting justice, for claiming that email to Baldwin was an attempt by me to get him to change his testimony. And so before we come on to the actual my arrest, which was in July 18, I'll specify it later on in the video, but with a completely separate incident. And you'll see how relevant it is to this incident in due course. And I mentioned it earlier in the video. And this is an incident that occurred on the 15th of January 2015. Another dangerous driving incident, almost identical to the type of dangerous driving I complained of with Uslati. In terms of driving, when somebody says a judge has painted a target on your back, and I'll read you out, or I'll show a brief caption of the statement that was given by Judge who was then Mr. Justice Warby, as I've mentioned, he's now a Lord Justice. But Mr. Justice Warby is quoting from a quote from Mrs. Justice Swift from 2012 in a judgment, a judicial review application from me, in which she accuses me of basically being paranoid and making false allegations and thinking that everybody is against me. There's no substance to any of my allegations, or she doesn't actually specifically find that, but she generally says that nothing I say should be taken, everything I say should be taken with a pinch of salt and effectively treated as false, because I'm this wild-eyed, paranoid lunatic that thinks all public servants and all members of the judiciary are against me and have got the knives out for me, to that effect. The exact quote will come up. I haven't memorized it, but then this quote is then taken up by who's now Mr. Justice Cotter, who was at the time a circuit judge who was from Exeter, who got drafted in from Exeter primarily to hear a load of civil cases I had against the Avon Somerset Police, or the Chief Constable of the Avon Somerset Constabulary, in around 2013-14 time. And he borrowed that quote, so that this quote is now being handed down from judge to judge. So rather than the judge being independent, the judges are simply falling in line with this one paragraph from Mrs. Justice Swift. And then is quoted by Judge Cotter, as I say, in his judgment against me, in which he awarded me £1 for being falsely imprisoned and injured by the police on a false imprisonment allegation, or charge, or civil charge. And then this again was borrowed by Mr. Justice Warby, and as I say, you can see the quote here. So you know, anyone who's made subject to such an order or such a judgment, which then feeds into the orders against me by the judiciary, and says that I'm a malicious, a vexatious litigant, and treats everything I say as vexatious and effectively false. Then obviously this is, you know, the way to express that is to make a fatwa. They've effectively put a fatwa on me and to put a target on me. And of course this is generally meant figuratively, but it's not. It's actually meant literally. Literally, people are being permitted to throw weapons at me. If you go to my video documentary, Judge Martin Picton Must Fall, in which a missile is thrown at my head by somebody in a supermarket, of just one example, a container misses me and smashes near children, as I've gone into detail about that, and that's fully substantiated. That's even accepted by the police that happened. But that's just that, you know. But then the cars are being driven at me, and so on and so forth. An almost identical situation in January 2005 to the one in September 17 has occurred. This incident, just to give a brief summary, I won't go into absolutely excruciating detail about this case, because indeed it's fairly straightforward anyway. But on the evening of the 15th of January 2015, I was cycling down Hurlingham Road, which is a steep hill going downhill in sort of at the top of near where I live, so about a mile out of central Bristol, and just round the corner from Cheltenham Road, where the other incident happened. A driver called Paul McBeath was driving. He was pulling out of a side road, and I forget what the name of that road is. I think Wolfingdon Road. And he as he was pulling out, he had plenty of room to manoeuvre around me, and I was coming, so we were sort of effectively heading towards a collision. But of course, I had right of way because I was on the main road going down, and he was coming out of a side road. But in any event, I'd slowed down enough for him to pull out, assuming that's what he was going to do, and he did pull out. But instead of going across the road to get onto the left side of the road for him to go in the direction he was going to go in and stay on the legal side of the road, he actually veered to his own right. So he came, he did effectively a U-turn, smashed straight into my bike, whilst I was on the correct side of the road. I had lights on. It was evening, but I had lights on my bike, and there was a huge traffic light, not a traffic light, a street lamp over where the incident happened. It was perfectly clearly lit. I had lights on, and he saw me, and I could actually see him seeing me as I approached. And assumed that, and was actually slowing down to give him space to pull out, even though he was doing that illegally, and he should have let me pass. And the impact of the vehicle, as you can see, left this huge, knocked the wing mirror off the right side of his vehicle, and the hinge where the wing mirror had been then just gouged a huge chunk out of my right thigh, and then knocked me clear off the bike and sprained my wrist, bent my the wheel of my bike double, and effectively left me for dead as he carried on up the road on the right side, on the right, and then parked his car up. And then he came down and started speaking to me and asked me, like, "Are you all right?" As though, which I took to be completely sarcastic and hypocritical, because there was no question that he'd seen me and that he'd deliberately driven on the right side. What was he doing driving on the right side of the road, even if he hadn't seen me? Because obviously the right side of the road is the wrong side, because we drive on the left in this country. And he, rather than go on the left and carry on up the road, which appeared to be where he was going, as I say, and I said, "Look, just call the emergency services. I'm covered in blood. I'm in extreme pain." Obviously, I wasn't saying as calmly as I am now, but obviously, once the police turned up, I was going to make the complaint that he'd driven at me deliberately. Again, as in, unfortunately, with the same situation in Cheltenham 2 years later, I didn't have my mobile with me, so I assumed he had his, and he did. I think he was holding it in his hand. I said, "Could you call emergency services?" Like, he refused. No word of a lie. He admitted this to the police later on. He refused to call them, and I said, "Look, I need hospital treatment. My leg has been severely gashed. It may be, it's quite near to main arteries. I'm in a state of shock. Could you please call emergency services? And of course, we need the police here to record, the aftermath of the incident." And he refused. And this became more and more heated. Two individuals came out of one of the local nearby houses and took Mr. McBeath's side and said, "Why are you shouting at him? Why are you being aggressive?" And even while blood is pouring down my leg, they didn't see the incident with the vehicle to know whether it had been deliberate or not. And he just stuck to his guns and refused to call emergency services. And one thing led to, I said, "Look, if you do not call the police, I'm going to hit you. I'm going to, in terms of the duress, in terms of life-threatening situation." And the other two individuals wouldn't call the police either, or the emergency services, either an ambulance or the police, even though they'd come out of a house and could have presumably had access to a mobile phone, if not a landline. And I did, eventually, one thing led to another, and I smacked him in the eye. And I don't think I smacked him hard enough to give him a black eye. They said I gave him a black eye afterwards, but I was well within my rights. I was clearly in a life-threatening situation. And he was clearly terrorising me and harassing me by refusing to call emergency services, and he was presumably legally obliged to do so after the incident that occurred. So because I had hit him, he then called the police to say that I had assaulted him, and so on that basis only did the police arrive. And of course, this is again their modus operandi: wait until I respond to some life-threatening terror situation, sometimes being committed by the police themselves, or often being committed by the police themselves. But whether it's a civilian or a security guard, it's to wait until I've actually finally responded to some full-on attack or life-threatening situation, and then they will start pursuing me as the scapegoat in any and every situation. So the police turn up, and one of the officers who turns up is a man called there's two officers turn up. One is called, rather oddly, Dennis Green. Well, that's how it's, I presume it's Denny Green, because it was a female officer, and one called Ben Vokins, who is now, yes, you guessed it, he's been promoted to a Sergeant Vokins. But at the time, and here's a photo of him, I can't find an image of PC Green. I think she might have left the force, actually, but I'm not entirely sure, but there's no online presence of her. But this is Ben Vokins. And Ben Vokins was, among many officers, who was found guilty of assaulting and falsely imprisoning me in 2010 in an April, in a decision by, on the 29th of April 2010, in a decision by a recorder, Michael Norman. So, of course, you can imagine I'm going to get short shrift from Ben Vokins. And Ben Vokins made it quite clear that he found the whole thing hilarious. He thought it was absolutely hilarious that I'd been knocked off my bike, and it was a kind of a bit of the, he's treating as Mr. Grey getting himself in one of his situations again. And of course, the more he was getting amusement from it, the more, and obviously grinning, in this kind of sadistic thing that the police, A lot of these officers that I had, the amount of sadism and pleasure they get when they've got someone like me who's litigated them, and they've got some sort of vendetta or past history, and they think they've finally got one over on you, they've got power over you. They get this horrible evil grin that is straight out of these movies. You think these movies are are over the top, and they all these get these ham actors, often English actors in American films, to do these kind of sinister kind of grinning enjoyment of other people's displeasure, as the Germans call it, Schadenfreude. This man was just clearly loving the fact that I'd got myself into this. I'd nearly been killed, and now I was potentially got a case against me for hitting Paul McBeath. But anyway, as the situation unfolded, my main concern was obviously getting to a hospital, because I was obviously in some degree of shock from the assault from McBeath, and of course to get a record of where the vehicle was, and the aftermath of the scene, and my damaged bicycle, and where the bicycle was, because the bicycle was because it had knocked. He'd knocked, because I tried to avoid him. We'd been going side to side, effectively like jousters who go side to side on their horses. And he because he was he'd done such a U-turn and gone to the right of the road. He'd knocked me into the onto the left-hand side of Wolfenden Road, or the side road. It was important, and then he carried on driving up. So it was important to photograph, or to catalogue where the bicycle was in relation to the vehicle, because the bicycle was, if he'd stopped immediately that he'd knocked me off, which is what he claimed, then of course the bicycle and the car would have been in the same place, or nearly the same place. But the car was well up Hurlingham Road, and the bicycle was actually on the left side of obviously left as you're going down with me, on the left-hand side of Wolfenden Road. So it was important to point out where the car was that he'd carried on driving, even though he must have known he'd knocked me off the bike. Otherwise, why did he stop at all and come to see how I was? And of course, there was the fact that he refused to call the police. I mean, what more evidence, or an ambulance, or emergency services of any description? And there was no dispute that dispute occurred. There were independent witnesses who witnessed the dispute about failing to call emergency services. So what more evidence of a deliberate, malicious attempt to cause me harm can there be than the fact that he refused to call emergency services afterwards, let alone the fact that the vehicle, the place of the vehicle and the bicycle proved clear-cut, deliberate, that he wouldn't have, if he hadn't deliberately knocked me off the bike, why on earth did he carry on driving, another 20 foot up the road before he stopped? So it was important to catalogue the position of the two, the vehicle and the bike, and I've got an excerpt of the pocket notebook of PC Green, because PC Green says that she had to intervene because she thought that things were getting heated between me and myself and PC, as he was at the time, I think at the time of PC Vokins. He might have been a PS. He might have been promoted because, of course, as he had been involved in my false imprisonment in 2010, and all of that, then that's, of course, that in itself would probably be enough to get him promoted, especially as there'd been a formal finding that he had falsely imprisoned me. What more, as I say, in terms of the modus operandi of the police, to immediately promote anybody that comes anywhere near the cover-up of some violent offence against Mr. Gray, whether it's the police or somebody else, immediately gets a promotion. But in any event, PC Green's pocket notebook states the following. I won't read all of it because she took me to hospital afterwards and so forth. But I think she's quoting from what I had said. Yeah, that's right. So she's quoting from me, what the evidence I'd given her and was later to sign at the hospital. I was cycling down Hurlingham. She's misspelt it, but that's Hurlingham Road, I think it is. Hurlingham Road. My bicycle lights were illuminated and I was travelling at a reasonable speed. Upon my approach to Wolfenden Road, which is a junction on the left side of the road, I saw a car approaching the junction. The vehicle, something crossed out, did not stop at the junction line. The vehicle turned right towards me. He was on the wrong side of the road, on Wolfenden Road, and as he turned onto Hurlingham Road. He remained on the wrong side of the road and was driving towards me. As he was so far over on the wrong side of the road, I manoeuvred myself and my bike to avoid him. However, I was unable to and became sandwiched between his car and a parked car. There is no doubt in my mind this was a deliberate act. The parked car was on Wolfington. It's supposed to be, I think she says Wolferton, maybe it is Wolferton, but I think it's Wolfington. But either way, we know what we're talking about. On my left side, approximately 5 meters from the junction line. From the collision, I have an injury to my right leg, which is causing great pain and is swollen, and it hurts to put weight on it. I have a bruise on my leg. An object from the car was dislodged during the collision, and I believe it was this object that hit my leg. So yes, of course, when I'm describing the evidence that it was a deliberate attack from Paul McBeath, I forgot, of course, the key evidence was the striation patterns on my injury to my right thigh, which of course you can see on the screen here. Which is obviously, which if it had been examined, would have been forensically identical to the hinge, the pattern of the hinge that was left when the wing mirror had been knocked off. If Mr. McBeath had been pulling out from my left, from Wolfington Road onto Hurlingham Road, the only way that he could have caused that massive injury to my right thigh, which has left a permanent scar there, was for him to have deliberately driven so far on the left that he knocked me off the bike and indeed scratched a huge chunk of flesh off my thigh before knocking me onto the pavement. Otherwise, how else could he have got so close? If he was driving anywhere in the normal position he should have been, because we're going parallel. There's only one way he could have caused that injury, and that is if my bike is parallel to his vehicle. And the impact is so hard that he's actually knocked the wing mirror off and then carried on driving to cause the striation patterns on my leg. So that was the key other bit of evidence. And of course, where the wing mirror was knocked off would have been where the wing mirror actually lay on the pavement would have been another bit of evidence. But of course, to take a photograph or have CIS who investigate these kind of things could have compared the patterns of the injury and patterns of my injury to the hinge of the wing mirror. And that, so the aftermath was, the consequences, you can probably imagine, was to in fact charge me with assaulting Paul McBeath after interview, and I gave the account that I've given to you after the interview to say that McBeath had clearly attacked me generally, so he should be prosecuted for dangerous driving, for attempted GBH murder, because he could have clearly killed me. As I've said in terms of the incident in Cheltenham Road, I could have had a child on the back of that vehicle. I could have been a child myself. If Mr. McBeath wasn't aware of my presence at all, which is what he presumably claimed, or words to that effect. But before we come on to the prosecution of that and how that was covered up, and of course the involvement of Judge Horton, the most evil, one of the most evil judges you will probably ever hear about, because apart from anything else, there's already been a finding about how much he has used his power in a separate matter. But first of all, there was in a very, very rare, almost unheard of situation where the police accepted to some extent that I was the victim of the dangerous driving from McBeath. The issue was whether it had been deliberate or not, or just bad driving on the part of Mr. McBeath. So this was a decision from a letter dated the 16th of January 2015. So I think I said the 15th of January. It's actually the 13th of January, so forgive me on that. The incident between myself and McBeath happened on 13th of January, so within 3 days. So this is presumably because before Police Sergeant Dave Russell, who made this decision of this letter, knew about me, had spoken to enough senior officers who said, Mr. Gray is never the victim under any circumstances. However much perjury we have to produce, how much evidence there is proving he's the victim, He is never the victim. That is official policy from the Avon and Somerset Police, if not all the police in the UK. So I'm presuming this is why he found a little bit in my favour, but of course not very much. So again, it's a qualified, what I just said a moment ago is qualified by that. But let's read the letter. With reference to the road traffic collision that occurred on Hurlingham Road, and it is Hurlingham Road, so I'm correct on that, on 13th of January 2015, I'm writing to advise you that it appears clear that the driver of the other vehicle was at fault for the collision and that a file has been submitted to our Traffic Prosecutions Department recommending that he is required to attend a driver education course. This is an alternative to prosecution and in this case is considered a proportionate and most appropriate method of dealing with the offender. This course is a requirement with the cost being met by the offender who, should he fail to attend, may face prosecution for the offence of driving without due care and attention. Any action brought by the police or Crown Prosecution Service does not preclude you making a claim against his insurance for any damage to your bike or personal injury received. I'm unable to offer you further advice about this. Well, of course, on that, I could have made a civil claim against him for assault, even if the police hadn't said he had assaulted me. But of course I couldn't because I'm subject to a general civil restraint order because Judge Warby and in particular has made it clear that there is a target, a literal target painted on me, and that people are encouraged to attack me with weapons, and whoever may be in the vicinity, that's all fine and dandy. So I cannot get any compensation, any justice for any, even if my leg had been severed or both legs had been lost, I still wouldn't have been able to sue Mr. McBeath because of the restraint order put on me by the corrupt Judge Warby. But anyway, let's continue with this letter. For your information, the other party is insured with Admiral Insurance, and the registration of the car is YH53 KWV. I'm assuming that isn't his registration, but if it is, let it be known that it is. You might want to steer clear of him if you're on a bike and in his vicinity. Anyway, he goes on. I note that you still believe that this incident was a serious assault. We do not consider, based on the evidence available to us, that this is the case, and there is nothing to suggest beyond your assertion that the driver intended to hit you. Furthermore, a serious assault would suggest that an offence under Section 18 or 20 of the Offences Against the Person Act 1861. For these to be made out, there is a requirement for a serious injury to have been sustained. The leg injury you sustained would not amount to such an offence under the Crown Prosecution Service charging standards. It isn't. So I'm just going to deal with that because otherwise I'll get lost about this. I'll forget when I get onto other matters. But two things there. Well, the conclusion that I wasn't, the driver didn't deliberately knock me off Mr. McBeath did not deliberately knock me off the bike, did not make a beeline for me in the same way that you can see Uslati doing, is because my counter allegations were never investigated. I wasn't permitted to give a witness statement, to give my account, my version of accounts. McBeath was about me hitting him, but I wasn't about him hitting me with a deadly weapon. And of course, if I had given a witness statement, then there were other issues. There was the issue that the police never took. Well, they did take photographs. I insisted before I went to the hospital with PC Green that she take photographs of where the wing mirror was, where the bicycle was, and where the car was, to prove that the extent of the attack deliberately occurred, and it wasn't an accident. No description is given by Dave Russell, about what his version of events or why he agrees with McBeath's version of events. But of course, for the reasons I've just stated before I read out Russell's letter, there was the striation patterns on my leg. So how could we have been parallel? If I was assuming, Mr. McBeath was at fault, then the police must accept that I was on the correct side of the road. How else could the wing mirror have been knocked off in passing and made the striation patterns to my leg? If the only alternative, given the positions of where the vehicle was to the bike, is that he'd impacted me head on, that would have been, if he'd not been looking and I had suddenly appeared, even if he didn't see my light, that might have been a justifiable accident because he didn't properly look, he was distracted or whatever. And so it would have made some sort of sense, if it had been just an accident, for him to pull out of the side road and then hit me head on. or then hit me, or at least the corner of the car, or my bike, or the front wheel hitting, or the front of my bike hitting the front chassis of his car, the front part of his car. All of that would make some sense in terms of an accident if he was driving carelessly, but vaguely in the correct direction, which is to cross over onto the left side and then go uphill, or even the right side, because in either event he's pulling out of the side road. But how on earth could he have been so? Could a collision have occurred where the collision wasn't between me and the bike, but my thigh and his wing mirror? To the extent that the wing mirror is knocked off, and the patterns, if you compared the patterns to, as I've already said, if they've got CSI to compare the patterns of the vehicle of the hinge from the vehicle to my injuries, it would have clearly shown that the injury how else would I have got this kind of injury that you can see on the screen, except by a scraping along of a sharp object, namely the bracket from the wing mirror. So and because there's been no investigation, then Paul McBeath can be just had a little tap on the wrist with dangerous driving, and I'm accused of lying about the incident only because there had been no investigation whatsoever in terms of how the incident happened. And of course, the photographs became a key issue when I was prosecuted, of course, for the hitting McBeath, as we'll come to in a moment. The photographs disappeared. They weren't made available, and that was the only evidence I could have had proving the extent of deliberate, because they refused to investigate the striation patterns compared to the vehicle hinges. The only alternative, or to add to if they had investigated that, but in the alternative, there was the position of the vehicle compared to where McBeath, because he said he stopped immediately after hitting me, and I said no, that's not true. The vehicle was another 20 yards up the road from where my bike was. So the photographs weren't produced, and we'll come on to that in a moment. But everything Russell is saying is complete fabrication, and based on the fact that they refused to investigate even take a statement from me in terms of how the incident. I said the incident happened against the McBeath version, and the only person that was allowed to give a sworn statement about the incident at all was McBeath, just in the same way that Uslati was the only person who was permitted to give a statement in terms of the incident in 2 years later. It is unfortunate that we have to deal with collisions on a frequent basis where the poor standard of someone's driving has resulted in injury and damage, but we are committed to promoting and improving road safety. This is why we have decided upon this course of action using the appropriate legislation. I understand that you will be disappointed with this outcome and would strongly urge you refrain from taking any direct action against the other party, in particular your threat to make a citizen's arrest. Any action should be undertaken using appropriate civil remedies or using the complaint mechanism in place, as failure to do so may render you liable to legal action. So there's a good old threat coming in there. I think I probably did mention citizen's arrest. I would have been totally entitled to it to do so. But I didn't, apart from anything else, I didn't know where Paul McBeath lived. But he's right. The civil remedy would, of course, have been to civilly litigate, before I litigated McBeath, but litigate the police for perverting justice and effectively colluding in the attack, and certainly colluding in the cover-up, because they refused to properly take, to forensically investigate where the car was and the imprint on the injury, and how McBeath says. How could he possibly explain in relation to Hurlingham Road to Wolfingham Road, and where his vehicle was, where we agreed initially that I was coming down Hurlingham Road and he was coming out of Wolfington Road, how that injury to my leg occurred and how the incident occurred generally. And of course, so I could have civilly litigated against the police with a decent lawyer, and had the police there would have been clear evidence of Vokins and Green covering up and not properly investigating the scene and the incident, and Mr. McBeath initially, who should have been arrested, of course, for the evidence of attempted murder, GBH. before I even worried about litigating Macbeth himself. But of course, again, the civil restraining order, Mr. Gray's an enemy of these judges. There's a big fat a bullseye ring on him. Anybody that wants to take a pot shot of him are encouraged to do so, because of course the more I'm out here blathering away about how corrupt judges are, even if I've only got like 20 or 30 hits for these videos, even though I'm saying I've got evidence of the most serious corruption and collusion by the judiciary and the police, and so forth. But obviously, whilst I'm at large, I can be making these allegations and making these judges feeling uncomfortable, and that they themselves may one day get a knock at the door. And certainly, at one stage, I may be somebody from the press. It's a forlorn hope, it seems, in this corrupt, horrible country that we now live in. But there is a chance that some journalist will independently scrutinise these judges and what's going on in the law courts. Which is when you're talking about court reporters, that's their main operation, not simply be the mouthpieces of the judiciary, which is effectively what they are. Of course, we do, as I say, returning to that judgment of Judge Tracy Lloyd-Clarke, of course, we do know that a lot of people do get quite angry about paedophiles not even going to prison for one day, and so forth, so it's not entirely a given that the judges in the country will just simply they rely on the fact, which is of course untrue, and I've mentioned in my other documentaries that they are not subject to criminal prosecution for conduct they do as judges. That's complete fabrication. I'll just repeat the authority of R.V. Bembridge and R.V. Llewellyn-Jones. These are both authorities that have established where judges have gone to prison or certainly been prosecuted successfully for the misconduct in public office. So the official line that they are completely unaccountable is it's self-fabrication, and the fact that the press think that still is the case or don't pick up on it and report the actual facts, again, is evidence that the judiciary feel that they're above the law and unaccountable effectively as tyrants, and obviously, hopefully, things will take their course. But now we come full circle, because of course I pointed out the similarity in the nature of the original incident, because both of these incidents have happened where there's clear evidence that the vehicle has travelled on to the wrong side of the road. Of course, in both cases, those vehicles would be permitted, presumably, to cross the road to park. But in neither case is there any evidence that these vehicles were crossing the road to the wrong side of the road to park. But of course, if they want to park on the opposite side to the road to where they would be driving, then they want to make sure that the traffic is clear, that there's no pedestrians or cyclists that might get mown down in haste to get to the other side of the road. But in both these cases, they're identical in terms of the what's going on in terms of the vehicle crossing over to plough into me, or nearly plough into me in the case of Cheltenham Road. As I say, I was then prosecuted. So before we come to the letter from Stuart Toms, which is what does bring us full circle, there is an email which again sums up the extent to which all these individuals, Russell, Stuart Toms, not Baldwin, because I think Baldwin was simply a useful idiot. He was just some guy who just got sucked into this literally bloody nightmare, this web of evil that's been spun around, that effectively exists around me because of all these corrupt judges and police officers. But they're all under, as I keep repeating, under the judiciary. It's the Bristol Crown Court judiciary, and then with the High Court judiciary in their pockets, who are actually guilty of all this evil, and that is the only word I can use. It is evil. It is the extent of somebody hits somebody or does something terrible in a heated situation. That's one thing. But when it's premeditated and it takes place over in this case over the Cheltenham Road incident, 2 years, and the extent of knowledge and the effect it's having on the wider public, which is what happens when judges abuse their power, or police officers or CPS officers, etc. So what's happened is I'm prosecuted and I'm convicted in the magistrates' court for assaulting McBeath. And there's no point in rehashing everything that I've said about the evidence that McBeath had deliberately assaulted me and the police were colluding in that, because it's an abusive process. If clearly if a minor charge is brought out of the fact that the person who's being charged is actually the victim of the most serious criminal acts from the other party, the person, the so-called victim, and then the police and the CPS surrounding that. So there was glaring evidence that not only that I'd been attacked by McBeath deliberately, with malice aforethought, and he nearly killed me and could have killed any child that was on that bike, etc. But then the cover-up from PC Green and PS Ben Vokins, the fact that they did actually take photographs, and this is what I'm going to come to, and obviously the failure to properly examine my injury in relation to the car and McBeath's version of events. And so I'm prosecuted, I'm convicted, I'm given a suspended sentence, I think, of a few weeks, which may have eventually been activated anyway. But then I appeal it to the Crown Court, and the matter eventually goes before a recorder, Qureshi, who I think is probably almost certainly now a Crown Court judge. I'll look it up, and if he is, I'll make a photo of him. I've got a photo of him, but I'll put I'll check it up before this video is actually put online, and if he's been promoted to a Crown Court judge, I'll make that clear. And of course, it's worth pointing out, just as a sort of a side issue, which is of interest to some people maybe. He's also a Sharia court judge because he's a Muslim as a matter of faith, and it's been permitted in this country for some time, as I understand it, that they have Sharia courts. They have Muslim courts that run parallel with the traditional courts that we have in this country, and they people who they can settle marriage disputes and so forth in the Muslim way, according to the Sharia courts. But it may be just a coincidence, but of course the fact that I'm effectively being, as I say, made subject to a fatwa by the judiciary in this country because of all the things I've said about their judgments and its effect on the fact that police are being permitted to allow me to be assaulted either by other police officers or members of the public or whoever just simply wants to literally tear a bit of my flesh off, or as McBeath is permitted to do, and so forth. And then, but of course, it may be just a coincidence that obviously that they had a judge that deals in Sharia courts, because of course it is part of Sharia law that the Taliban, for instance, which operate effectively as they do in Saudi Arabia, effectively operates under Sharia law, which permits those in authority to behead and commit corporal punishment on members of the public who the powers that be deem have fallen foul of whatever Sharia law regulation may occur. So obviously, apart from anything else, Mr. Qureshi is a recorder, so he's ambitious, he wants to get promoted, and he made it quite clear that he was following his judgment, and he upheld, of course, the conviction and upheld the sentence. So that was that, as far as I was concerned, for the same corrupt reasons that occurred in the magistrates' court, for reasons that I hope are now clear in this video. But he made it clear that he was operating under the ruling, effectively, or the rulings of Judge Horton, because Judge Horton had been appointed to sit as the case managing judge. So before the trial was heard before Qureshi, and of course these are summary proceedings because it's a common assault against Paul McBeath, so it doesn't go before a jury, which again, all this talk in this country about we have a great system because we have a jury and people are judged by their peers, utter rubbish, because people can go to prison for years and years and years if they continually up before the magistrates without going anywhere near a jury. And so anyway, I appealed the conviction. It then went before Judge Horton, who then is the case manager, and he makes decisions about such things as what evidence should be disclosed to the defendant in my case. This email that I'm about to read out is from Zoe Holloway, who's a court manager at Bristol Crown Court, and she was following up. So the trial, the proceedings is this is case reference 2015 0308 to do with the common assault appeal against the conviction of common assault from Macbeth in that was the conviction in the magistrates court, and when you appeal it, you then get a judge who's usually, not always, but usually a Crown Court judge who's got some experience as a Crown Court judge, but that's not to say they're not as corrupt as Des Long, as indeed Judge Horton is, and two magistrates, usually either very rarely actual district judges as such, so that they will again be just lay magistrates in the same way as you'll get three lay magistrates in the magistrates court, except you'll only get two of them. But they're just there for decoration, because clearly the only person the only person that has any weight in terms of decisions that are made by the Crown Court in the Crown Court proceedings is the Crown Court judge. He's the circuit judge, he or she. And so what they say goes, and of course it doesn't really matter what. They may have some influence in a trial that goes all the way to full trial, but the single judge would have the decision in terms of an abusive process, so dismissing the case because it would be illegal to prosecute me, because it would be clearly unfair, or there'd be some other major abuse, such as there clearly was in the prosecution concerning Macbeth as the victim in this case, then. Again, with no case to answer, I think that's usually just up to the judge rather than the lay magistrate's court. But of course, it'd be quite odd for a lay magistrate without any legal qualifications at all to gainsay the position of Judge Horton. And Judge Horton, of course, knows me very, very, very well, because I've been continually up as a defendant in person and as a civil litigant in endless proceedings in Bristol Crown Court. And indeed, in one case, I remember having some sort of argument with a security guard, and Judge Horton was strolling by, and he has this whole sort of old boy image of with the moustache and the bowler hat, and the bowler hat might be my sort of embellishment, but and the umbrella, and I remember him strolling past, and he actually said something about me. There was an issue about representation. I can't remember the details of it. It may be that I wasn't permitted to question witnesses. There's called a special measures, which is usually involves child abuse cases or cases involving children where there's a child complainant, and so that the defendant isn't, if they're in person, isn't permitted to directly question a vulnerable witness of that nature, which is perfectly reasonable. But it didn't. There was no vulnerable witnesses in terms of Macbeth. Macbeth had knocked me clear off my bike, left me permanently scarred, a huge scar to my leg, and severely had me hobbling around for weeks. And I didn't hit him very hard anyway, and had perfectly reasonable justification, because he didn't dispute that he didn't call emergency. He was refusing to call emergency services, and indeed, Recorder Qureshi, made some concession to the inhumanity of the proceedings by saying it was unconscionable or something along those lines, that he didn't call the police, but that didn't justify me hitting Macbeth. But the CPS and or the court will use the special measures criteria in order just to prevent me questioning witnesses of relevant questions that need asking. It wouldn't apply to questioning the police, but certainly to Macbeth and I think the two civilian witnesses. So when this issue came up, Judge Horton allowed the application to involve the special measures and to have a barrister question on my behalf. I forget who he was now, but because he said Mr. Gray often harangues people. So he was clearly referring to an argument that he's seen, not knowing anything about the circumstances of years before, involving myself and security staff. And he's involving his personal view of that situation completely violating my Article 6 human right to an independent judiciary, making rulings on his own personal involvement in a situation outside of the courtroom, of which he knew nothing anyway. But so this is the extent of corruption. But the key point that I'm raising in terms of the correspondence was that at a hearing, I'll see if I can. I'll read out the email, and then I'll go into a bit more of the details about it. Mr. Gray, this is from Zoe Holloway on the 15th of January 2018. Please see below response from HHJ Horton, and please note that HHJ Horton does not wish to engage in any further correspondence with regards to this matter. I should just actually just finish off, because I've discussed Horton's character. He's now since retired, and he was only sitting for a year or so after a decision had been made by the, and I'll come up on the screen, the finding of the Ministry of Justice, who investigated Judge Horton, because Judge Horton was involved in some civil private matter involving, I think, a land dispute or a dispute over property or inheritance or something that he thought he was entitled to. And he was using his judgeship. He was getting in touch with the other party and saying, words to the effect of, "Look here, I'm a Crown Court judge. Have you any idea of what I can do, to make your life miserable with using my power as a Crown Court judge?" And he was rightly hauled over the coals for it. But of course, we have such a corrupt system that not only just the mere fact that he's been found to have abused his position of power and trust to his advantage, and to browbeat other civilians. But he just goes straight back on, and he goes straight back to sit on the bench and be as corrupt as he likes, as he's already proven himself to be with this finding by the MOJ. So that really shows you where we're at with the courts. And of course, again, I refer you to R.V. Bembridge and R.V. Llewellyn-Jones, which I've just mentioned, because of course he knows the judge should have been. That's clear evidence that the judge is abusing his position of power and trust, to the extent that he's committing the criminal offence of abusing his position of office. It's called misfeasance, the technical term, misconduct in judicial or public office, because of this absolute lie that judges are no longer prosecuted or can't be prosecuted, when the common law in this country for centuries has been that judges are and can be prosecuted as recently as the 1960s. For the misconduct in public office, and quite clearly for this kind of stuff that Horton was found guilty of by the MOJ, he should have been prosecuted for misconduct in public office, in line with the ruling of Llewellyn-Jones and Bembridge. But of course, rather than be prosecuted, he was in fact put back on the bench, and finally, as I understand it, thankfully being put out to pasture. This is, it's just, in and of itself, it should be of more interest to the press, the public at large, that judges who have such huge power in this country, far more power than elected politicians, should be accountable in this way. And it's just a story in and of itself. But of course, when you're actually certainly in person, going up against a monster like Horton, it just about says it all, that he had this history with him. So, anyway, returning, we've got into a little bit of Judge Horton's bad character, but this, as I say, is more evidence of it. It is my recollection, this is the judge quoting now from Miss Holloway, the court manager. It is my recollection that during the hearing I conducted in this case that, 1, I was not told photographs existed. This is photographs taken by PC Green of the aftermath of the incident between myself and Macbeth. I recollect that I ordered the Crown to disclose photographs if there were any, underlined. Had the Crown Court physically have been in possession of such photographs, it is likely I would have ordered laser copies at the least to be disclosed that day. I never saw any photographs. I had conducted previous hearings with the defendant on earlier cases, and ensured at directions hearings that anything which could be provided on the day of the application was available should be provided that day, as the defendant was not represented to ensure he had them. It is for that reason I am certain I saw none and made the order I did. 2, it is further my recollection that there was considerable discussion in documentary form from the defendant concerning the whole issue, and my comments indicated that at that time I could not see the relevance of the detail of the accident, nor witnesses relating to that matter, as I explained to the defendant at that hearing. The material before me suggested, as far as I now recall, it was not a serious incident as far as the alleged accident, in quotation marks, was concerned. As I understand it, number 3, as I understand it, it is alleged that there were no photographs, and for this reason no order of mine was flouted. I therefore make no further orders in respect to this matter, HHJ Horton. This correspondence was after I'd been reconvicted by Judge Qureshi, or Recorder Qureshi as he was at the time. So it was simply a matter of getting evidence to prove perverting justice around the original investigation. Now, let's look at what Horton is saying. First of all, these proceedings were recorded. That is the point of recorded proceedings before judges in criminal cases in the Crown Court. They're not recorded for reasons entirely not clear in the Magistrates' Court. So if people perjure themselves silly in the Magistrates' Court, there's no proper full evidence that perjury has taken place, for instance, because they're unrecorded. So it's entirely up to the judge in the Magistrates' Court, or the lay judges, about whether that evidence should be, whether there is any evidence of perjury. And of course, there's no definite evidence of perjury because they're unrecorded proceedings. But in the Crown Court, all proceedings, in criminal proceedings in the Crown Court, are recorded on sound recording devices. So why is the judge relying on his memory? He doesn't have to rely on his memory because it's all recorded. But he thinks it's so insignificant about the whether or not photographs were taken that he'd much rather rely on his memory. And he's an old chap. I don't know his exact age, but I think he's at the time he's writing this, he's in his 60s or so. And of course, he hears thousands of cases anyway every year, so he's not going to remember a trial that took place 2 years earlier, because he's writing this in 2000, not 3 years earlier, because he's writing this in 2018, and the trial, or the proceedings before the trial, were in 2015. So why is he relying on his memory? If he wants to be assured one way or the other about the facts of what decisions he made and what he was told by the CPS, he needs to listen to the recording. And the recording is absolute. It's not to be argued with about what's heard, but rather he would rather rely on his own memory from 3 years ago. And he even accepts that he's relying on his recollection. So that's the first point. The second point is these were recorded proceedings, and the CPS stated clearly that photographs were taken. There was a note on the record, the police record, although I wasn't given the record, that photographs have, or I don't think I was, I may have been, but I may have mislaid it. But the solicitor, the advocate for the CPS, is a man called Kenneth Bell. And unfortunately, I can't get a photograph of him, but he was the one who was prosecuting me for assaulting Macbeth. And he's not a barrister. It would usually be in a prosecution a barrister from a chambers, but there are these intermediate sort of solicitor advocates who aren't quite barristers, but they're solicitors. They're sort of between. They're slightly. They have rights of audience in Crown Court, which means that they can act as effectively as barristers, which is what Kenneth Bell was. But he was also from the CPS. He wasn't part of the chambers. Or a solicitor's firm. He was actually working for the CPS themselves. He's an officer of the CPS, so he's not even vaguely independent anyway. But he was happy to own up to Judge Horton when I said I need the photographs to prove that I was acting because Macbeth had deliberately driven at me and committed the offence deliberately. It wasn't an accident. And that's the other bit I'm going to come to in a moment about Horton referring to in quotation marks as an accident. The evidence I needed was to prove it was deliberate, and that the police had deliberately covered it up. So Judge Horton, he didn't need to rely on his memory. He could have played the recording. If he had played the recording, it would have made it clear that effectively Judge Horton is lying, because even if he can't remember, he's deliberately not refreshing his memory through the recording, so he can continue this fabrication that he wasn't told that photographs exist. Mr. Bell made it absolutely clear, and he was probably making it clear to mentally torture me, again, just showing me, just as we've all seen for the reams of evidence concerning the Cheltenham Uslati matter, is that they're rubbing my face. They're literally rubbing salt into the wounds, almost, in terms of proving how much corruption and deliberate malice and evil is going in to this prosecution by showing the extent of corruption in the original investigation. And of course, the extent to which they've got Horton in their pockets, because they made it absolutely clear that they had taken photographs, but they were saying they couldn't find them or mislaid them. So that I could have then argued that was, again, that I couldn't have a fair trial because they had lost key evidence proving that there'd been a cover-up of the assault, attempted murder from Macbeth. But even if Horton is correct, which he's not, but even if he'd listened to the recording, and I got it completely wrong, and the recording didn't show Mr. Bell stating that photographs were, there was a note on the police record that photographs were taken by PC Green. I mean, I was stood right there with PC Green, and she was never called as a witness in the trial anyway. But I was stood right there with PC Green, demanding and making sure she took photographs. She might not have taken them because I didn't actually see her mobile camera. But there was no. But if they hadn't, then that in and of itself is corruption. If Horton had been knocked off his bike, or PS Ben Vokin or PC Green had been knocked off their bike, and they were saying, look at the injury, look at where the vehicle is, look at where Mabith's car is, or look at where my bike is compared to the car. It was completely deliberate. It's a well-lit road. How could I be knocked off my bike on this side of the road if Horton is coming out of Wolfington? There's, if it happened at all, I would have gone. If he'd just been pulling out, as I've said, I would have gone into the vehicle and gone over the vehicle potentially, but I wouldn't have a side-on injury that's from the vehicle going parallel to my leg or in the opposite direction. So they would have expected, the very least, due diligence to take photographs to verify where the version of accounts that are from me and Beath, and then taking photograph of the injury and then compare that to the photographs of the striation patterns from photographs, or the actual hinges from the dislodged wing mirror. So. Either way, from either perspective, Horton knows full well that there was a cover-up from the police about they didn't take photographs of the striation patterns, they didn't take photographs of the hinges, they didn't take photographs. This is according to Horton's own view that although they did take photographs, and Bell made it clear they took. Of course, Horton could have contacted Bell, couldn't he? He could have said, "I am concerned about some sort of judicial cover-up from the CPS and police." So he could have contacted Bell and said, "Did you tell me?" If he can't be bothered to listen to the recording, he could have found out from Bell. But even if Judge Horton's right and that no evidence was given that photographs were taken, then that itself is evidence of cover-up. And even if there were photographs and that they had been disclosed to me, they still didn't forensically examine the injury to compare it to the striation patterns of the hinge. And you wouldn't really need to, because how else could that injury have occurred? And what other form or scenario did Paul Mabith, and importantly the police and the CPS, say that injury to my leg had occurred? So from any perspective, that Horton's rubbing salt into the wound and just boasting about what a corrupt animal he is. And then of course we come on to him referring it to an accident, and he was saying it was not a serious incident. Well, what he means is I didn't actually die. I was permanently scarred. I mean, ABH, actual bodily harm, which carries, I don't know, I think a few years in prison, is any injury that is the removal of skin, amounts to GBH, or any noticeable mark. Sometimes it's a toss up between common assault and ABH, actual bodily harm, but of course this was a weapon. So the cause being, if it was deliberate, this is on the basis that if it was deliberate at all, it wasn't an accident. And of course, the only way Horton can refer to it as an accident is because there was no investigation about the extent to which it was deliberate and Beath's version of events compared to me. I wasn't permitted to give a statement. There were no photographs taken of, according to Horton, of anything. So it's only an accident because he's abusing his position of power and trust, just as he did when he wanted to stitch up those who opposed him in the civil case. And you've got to bear in mind, Judge Horton is, judges in this country, circuit judges, in order to prevent them, one of the reasons they get paid so much is to prevent the temptation from being corrupt and taking bribes and so forth. They're already on $250,000 a year plus, and yet this judge is so corrupt. From the $250,000 a year he's already earning, he wants to abuse his position of power, effectively break the law, effectively be corrupt, abuse his position of power and trust, a public office, to get even more money that he thinks he's deserved and entitled to. And he's an old chap. He's not going to live forever. I mean, what he could possibly do or need extra, whatever it was that he was trying to, browbeat the people in the civil case about. And the same with me. He's far more concerned. His only interest is colluding in the cover up. It doesn't matter how brazenly corrupt it is. His only interest is to collude and to rub my head. So he must know the amount of psychological damage he's doing to me. Not only to have be the victim of this assault in the first place, this armed assault, which again I was going to say possession of an offensive weapon, because of course if he's used the car to cause an injury, that's possession of an offensive weapon, ABH. So that's serious. And of course there's the attempted murder, because the potential for me dying if he has deliberately driven at me at speed while I'm coming at slightly less speed, but certainly coming at speed in the opposite direction. The potential for a broken neck or permanent being disabled from such an impact is very, very high. So it's the attempt, it's the intention, it's not the success. The prisons are full of attempted murder, attempted GBH, attempted this, that, and the other, when people haven't died or haven't even been, injured even slightly. It's the attempt. It's it's the conspiracy, the terrorists. There's hundreds of prisoners in prison for conspiracy to commit terrorist acts and so forth, and they haven't even started to assemble a bomb or whatever. It's the intent. It's evidence that somebody plans or has intended or deliberately tried to do something, not the success of it. But in this case, McBeath was partially successful. He did leave me with a permanent scar. He did cause me to be limping for many weeks after the incident. Horton is calling it, he can only call it an accident, in quotation marks, because he's colluding with the police and the CPS, lying his head off about the cover-up of all the evidence that proved McBeath had deliberately driven at me. And of course, what is the key issue? There's no dispute that McBeath had refused to call emergency services, which itself surely is protected. He doesn't know how serious my injury is. For all he knows, if I hadn't hit him and forced him to call the emergency services because he was now the victim, or considered himself to be the victim, as now Judge Horton has decided he is, then for all he knows, if I'd let him drive off, then not only would there be no evidence to record the scene, which there wasn't anyway because of the collusion of the police, but I could have been bleeding out. I mean, at the very least, I would have been expected with my broken bike to be hobbling home or to the nearest hospital, which is 3 or 4 miles away, with blood pouring down my leg after this collision, because McBeath refused, by the admission of himself, not to call the police or the ambulance. So that deals with Horton, to the extent that I've now made a formal complaint to PSD, which of course is overseen by, yes, you've guessed it, Richard Budd, about Judge Horton. And I've said this guy is as corrupt as the day is long. He's lying about it. This is misconduct in public office. Judges are not, contrary to the official website, above the law, as I've established in terms of RB Bembridge and so forth. And I reported him to PSD, and PSD appointed a local mid-ranking CID officer, Stuart Toms. And Stuart Toms dismissed all my allegations against the evidence that Judge Horton, among others, against obviously colleagues of Stuart Toms as well, of colluding in misconduct in public office and perverting justice by concealing the fact that photographs were taken of the aftermath of the incident in order to create the fabrication that McBeath had accidentally knocked me clean off my bike in an empty road on the wrong side of the road and left me with a permanent scar and limping for weeks and with blood pouring down my leg. So this is the decision of Stuart Toms. And of course, this is what will lead us full circle into the Cheltenham Uslati in that case. So this is an email in the decision of crime incident 5/18/02 4336, and of course I haven't been able to make a formal witness statement, so any allegations that I've made something up against Horton and so forth they're not going to do me for perverting justice, even though that's the effective outcome of what they're saying. But anyway, Stuart Toms says on the 24th of February 2018 the following: Dear Mr. Graham, I write having reviewed your complaint of criminal collusion in attempted murder, perjury, misconduct in public office, possession of an offensive weapon, perverting the course of public justice. This appears to be against the following parties in the following abbreviated form: Paul McBeath, attempted to murder you with his car using it as an offensive weapon and later committed perjury in court regarding this. Judge Mark Horton suppressed evidence that Mr. McBeath had tried to kill you in respect to the photos, perverting the course of justice with his response denying he knew photographs existed. He is also aware of numerous previous complaints of major criminal corruption against his fellow judges by you, and therefore has glaring motive to collude in any attempt on your life. Recorder Shamim Qureshi, so we know his full name, suppressed evidence that Mr. McBeath had tried to kill you in respect of the photos. HMCTS officer Zoe Holloway, no direct evidence that she referred your correspondence to Judge Horton or Recorder Qureshi. Well, let's assume that she did, and assume that in any event, even if she didn't, Stuart Toms was required to directly contact Judge Horton as a suspect in an official inquiry of this nature. CPS solicitor Kenneth Bell perverted the course of justice by destroying - losing photographs of McBeath's vehicle in order to cover up evidence that McBeath had deliberately driven at him at speed and then carried on long after the impact. PC Green perverted the course of justice by destroying losing photographs. I make the modest assumption that the misconduct in public office also relates to the same complaints in respect of the relevant parties above, and that possession of an offensive weapon refers to McBeath's car. The material I was initially provided in respect of this consisted of your correspondence to Chief Constable Marsh, dated 24th of January 17, your correspondence to Zoe Holloway, dated the 1st of January 17, email from Zoe Holloway to you, dated the 1st of January 17, email from Zoe Holloway to you, undated with Judge Horton's response, email from Judy Dennis to you, dated the 22nd of December 17, one picture of an injury to a leg, one picture of an injury to a leg. Your allegations arise from your conviction, which was upheld at appeal for assault by beating and a public order offence following a driving incident at Hurlingham Road, Bristol, on the 13th of January 15. I don't remember any public order charge added. I think that's not quite true, but anyway. Circumstances of incident on the 13th of January 2015. At about 13th of January 15, there was a road collision between Mr. McBeath's car, which had pulled out from Wolferton Road, turning right into Hurlingham Road, and Mr. Gray, who was riding his bicycle in the opposite direction along Hurlingham Road. In the course of this, Mr. McBeath's offside wing mirror came into contact with Mr. Gray's right thigh, causing minor injury. I don't think this injury to my leg looks like a minor injury. It's removed a huge chunk of my leg. It's caused considerable bloodshed. It caused me to limp for several weeks, and it's caused a scar that's lasted the rest of my life. After this collision, Mr. Gray made threats of violence towards Mr. McBeath and assaulted him by punching him in the face and causing bruising to the left eye area of his face. Well, yes, I mean, the assault is only because I've been convicted after all the perverting justice that I've just talked about. Your allegations appear to be seeded in the belief that Mr. McBeath was responsible for attempting to murder you. This is something you appear to have alleged early in the aftermath of the accident, where you demanded police officers at the scene arrest Mr. McBeath for attempted murder and a serious assault. This demand was refused, and it was apparent to officers they were dealing with a simple but unfortunate traffic collision. So they're saying that Toms is saying that the police have already made up their mind. They haven't investigated anything at all. They know it's an accident, even though on what other basis, if it's an accident, how has it occurred in terms of a completely empty road and I'm cycling in a well-lit road with lighting on the correct side of the road? If it was an accident, have we heard anything yet from the letter from Dave Russell, PS Dave Russell, the explanation, the response from Judge Horton, anywhere? Is there any investigation or account of what McBeath has given versus mine to say why I am simply making up the evidence, making up the allegation it was a deliberate assault? They could see no evidence that would give rise to any reasonable suspicion that Mr. McBeath had intended to murder you. They assessed the primary fault was that of Mr. McBeath, but identified a number of points of mitigation, notably the wet road surface, the poor road layout and lighting, his view being obstructed by a parked vehicle. Well, that's another point that I made. There was no parked vehicle. The parked vehicle was completely fabricated. Again, why they didn't produced photographs that were taken by Green. So either they didn't take photographs. If you believe Horton's rubbish, then clearly if there were no photographs taken, then they should have taken photographs, because I'm saying that there was no obstructing car that Macbeth complained about. But even again, so I'll finish this paragraph. But there's yet another bit of evidence proving that my version versus the police Macbeth's version was accurate, because again that was why the photographs were necessary. And of course, the main thing that I'm laughing in just to get through the pain of it all. But the main reason the main thing Toms is supposed to be investigating is the lack of either the lack of photographs at all, or the lack of availability of photographs that would have disproved that there was a vehicle blocking the way in the first place. His view being obstructed by a parked vehicle, and not least his allegation that you had been cycling too fast for the road conditions and had been wearing headphones. It does appear from the evidence that you were unable to alter your course and or speed to avoid the collision, which is suggestive of some contributory lack of due care and attention. So again, it's actually me at fault. Although I've been knocked clear off my bike, although I'm the one with the scar and being forced to limp and blood pouring down the road and this injury here, it's actually my fault. Although technically it was Paul Macbeth's fault, technically it was my fault actually. Once it's gone through the meat grinder, the literal meat grinder of this barbarian Stuart Toms. You make specific mention of photographs taken of the damaged vehicle and its position. Right, so this is the key issue. You make specific mention of the photographs taken of the damaged vehicle and its position when the police arrived. You state they were taken by PC Green on a mobile phone minutes before taking him. So he keeps talking about you and him, so it gets very confusing because he's actually talking about me. So when he says you in the first sentence, he then says him in the second. So it's very difficult to know who he's, in both sentences he's talking about me, because he's then talking about me in the third person. You state that they were taken by PC Green on a mobile minutes before taking you, is what he means to say, to the hospital in regards to your leg injury, which he's meant to say, which he also photographed. You indicate these are essential to your defence, as they would help prove Mr. Macbeth continued to drive after his wing mirror had been dislodged from its bracket. You further indicate the striation pattern of the injury to your thigh matches his wing mirror bracket. This does not appear relevant to the criminal case appealed. It was fully accepted there had been a collision between his wing mirror and your thigh, causing the related injury. The case revolved around your unlawful actions following the collision. Well, no, that you see, I mean, I really don't need to read much more of the letter, and I won't, because there's absolutely no point, because you can see the extent of lies and corruption. I'll read a bit more, but there's only so much I can take, and that's worth looking at, because if the police are colluded by concealing evidence that the incident had been deliberate and not accidental, then my smacking the culprit of somebody that's tried to kill me would have rendered the prosecution illegal. It's called an abusive process. An abusive process is when the CPS have colluded in order to bring a prosecution against someone. In fact, I think the formal ruling is R.V. Maxwell. And that is the authority which says that it usually, but not always, relates to matters. So when a police officer goes undercover and they need to get evidence of somebody, who's dealing in the criminal underworld, and in order to go undercover, they have to, we know about the CID officer that slept with went undercover. This wasn't sort of drug dealer gangs, but had children whilst undercover with a woman that he was investigating undercover. And obviously when they get involved in drug deals and sometimes in violence, to the extent to which they're permitted, a prosecution can be based on somebody that they've caught by these methods, when the methods may be more illegal than the actual corruption that they are investigating. Well, in this case, if there was evidence that Macbeth had tried to kill me and that his driving had been deliberate, then the prosecution was illegal, especially if it's to try and get me convicted, get a suspended sentence for a summary offence of hitting Macbeth. and to what extent it's relevant is a judicial matter for the court at the time. All Stuart Toms he set out at the beginning of the letter what he's investigating. He's investigating any evidence of misconduct by the police and or the judge and or Macbeth surrounding the evidence of the attack that Macbeth had driven deliberately. So he's accepted that there's been no evidence gathering the evidence that it had been a deliberate driving offence rather than an accident, Stuart Toms is whitewashing and covering up that matter and simply saying, effectively saying, even if they did try, even if there was evidence Macbeth did deliberately drive at you and the police covered that up, that was irrelevant to the prosecution. But of course, what is relevant, even if it was irrelevant to the prosecution against me, it's not irrelevant to the prosecution that should have taken place against Macbeth and against Green and against Vokins and even Judge Horton. If Judge Horton is lying to cover up evidence of an attempted murder, because I mean, what Toms appears to actually be saying is even if there was evidence of attempted murder, it's irrelevant to whether or not you should have hit what you did was lawful or not towards Macbeth. And of course, he's whitewashed the fact that Macbeth refused to call emergency services. I didn't immediately hit him, as I potentially could have done, because when he approached me, I could have thought I was under further attack from him and hit him in self-defense. And if I obviously that would have been even harder for them to convict me on that basis. But I didn't just automatically hit him. I hit him after he refused to call emergency services, which of course Macbeth is omitting. And of course, if he refused to call emergency services, that's more evidence that the attack was deliberate, because he's causing me to suffer even further and potentially wants me to bleed to death or walk to hospital and bleed to death on the way, or hobble to hospital. And God knows what I'm supposed to do with my bike, because I didn't have a lock for it. And so forth. So look at the evil of this Toms. All he's done is he's making me relive the horror and the trauma and the unbelievable mental torture of just this man lying and lying and lying, just as Horton has done, just as Vokins and Green have done, just as Macbeth had done. And of course, if Macbeth's version of events, the key point is, of course, the prosecution, of course, as Toms is aware, the prosecution was based on Macbeth's version of events. So if Macbeth has lied, he's committed perjury and perverting justice. Notwithstanding, what he's lying about is attempted murder, which is obviously even more serious than the perjury and perverting justice he's later engaged in terms of the cover-up. Anyway, so he says it was fully accepted there had been a collision between his wing mirror and your thigh, causing the related injury. Well, no, the injury wasn't the wing mirror; it was the hinge that the wing mirror was attached to, that was the sharp edge sticking out of the vehicle, which was left when the wing mirror was dislodged, that has caused the injury. The key issue that Toms is ignoring is that is not a collision. I'm not colliding with the car, and how can an injury of that nature occur unless Macbeth is driving on the wrong side of the road at speed and continuing to do so that the injury occurs to the rest of my thigh. And of course, anyway, sorry. So post your unsuccessful appeal, I note you continue to complain to court officer Zoe Holloway regarding the aspect of the photographs. She liaised with Judge Horton, who responded as follows. Well, we read out Judge Horton's response. We don't need to repeat that. So confusingly, I won't read out all the bits and bobs about exchanges, because apart from anything else, there's no evidence that this is from these parties. That these aren't witness statements. Stuart Toms could be making this up, but it's, we've got the gist of what Stuart Toms is about. And confusingly, he says the conclusion, and then there's another conclusion. So I'll try and I'll read out the bits that refer to his conclusions. The conclusion that I reach, given that you represented yourself at both hearings, is that the original suggestion that such photographs may exist came into existence from you as detailed in your defence statement and was reiterated by you in subsequent proceedings. There is little indication at trial of your now specific suggestion that these photographs were vital to your defence. It appears the prominence of these rose at your appeal and in your complaints and allegations subsequent to its dismissal. It is also clear to me that no one else in the court on the 13th of January 16, and likely on the other occasions, knew whether your suggestion that such photographs had been taken was correct, as they had not been present at the material time. Well, this is all rubbish, because the proceedings were recorded. He doesn't have to worry about what he remembers or she remembers, what the judge remembered. All he has to do is get a transcript or get the recording of the exchanges at court. And then there's no dispute about what was said there. Therefore, you were given the benefit of the doubt and the order was made as indicated. I note quite importantly in your defence case statement that you indicated that PC Green had agreed to take photographs, not that she had actually taken photographs. I have made contact with PC Green, who had been on maternity leave, hence the difficulty others may have had in reaching her. She indicates the only photograph she took was that of your thigh. This is entirely consistent with her detailed pocket notebook entry. Well, if that's the case, then I've got to, as I've stated earlier to you, as I stated in my complaint to the judge or about the judge, then that's even worse, because if there weren't photographs taken, then that is itself a cover-up. If I've made allegations that the driving had been deliberate, there's glaring evidence from the nature of my injuries, from the position of the car, etc., as I've already repeated, then the failure to take photographs is only so that they cannot record any evidence that that McBeath's version of events was utterly fabricated, and the version of events that is given by me it cannot be proven, because the only way of proving it, well, not the only way, but largely the best way of proving it is in terms of the photographs of the position of the car, but not just the position of the car in relation to the bicycle, but of my injury in relation to the kind of patterns that would have caused it from the exposed hinge. And of course, there's McBeath's outrageous assertion that a key bit of defence that is raised by in the documentation, that McBeath's, raised by Toms, that McBeath's view was blocked by a parked car. I denied that under oath, and of course I couldn't prove it because the police, according to Stuart Toms' version of events, had not taken photographs at all. So that by not taking photographs, anybody can say anything they like, and I've got no way of proving one version over the other. And of course, it wouldn't really have mattered what version, even if photographs had been taken, because these judges are so corrupt, and the CPS is so corrupt, that they will just lie anyway, as Wasiak did under oath before Judge Harms in the Cheltenham matter, when he said that the CCTV disproved my version of events, even when the police went out of their way to get an independent witness, or PC Carpenter went out of her way to get a witness statement from, or get some testimony from Truslove, who said that he saw he backed up my version of events as well. So why bother? Why not just show the photographs? Because they know that they can go into court and Judge Horton or Judge Qureshi will just simply collude in whatever lie comes out of the mouths of these corrupt police officers and CPS officers, because I am the target. And we know why I'm the target, because apart from anything else, Lord Justice, His Lordship Judge Warby, has made me a target by his general civil restraint order, courtesy of the CPS and in particular the Avon Somerset Police. So he then says that there's another conclusion. So he's concluding. It's a conclusion upon conclusion. The conclusion I draw from this and share with you is that no other photographs of so grammatically nonsense, were taken by PC Green, and in my view, given the circumstances, there would be no good reason to have taken them. No good reason apart from the fact I was accusing this man of attempted murder. No good reason apart from the fact that I have no way now of disproving the vehicle. There was no vehicle blocking McBeath's way. That the striation patterns were identical to the exposed wing mirror, and no explanation. Again, no explanation from no details from Stuart Toms about how the impact could have occurred. So this is the last part of Stuart Toms' letter, and this is where it really does bring us full circle. Your suggestion that Mr. McBeath intended to murder you, I find to be not only without merit but spurious. Well, so he's accusing me of perverting justice by making false allegations, effectively, and would that he would charge me with that offence. This had been fully explored not only at criminal trial, but also subsequently on appeal against conviction. Not fully explored because all the evidence that proved my version of events was not addressed, hasn't been explored here, and of course there was no photographs to put my version against against Macbeth's. Due to the evidence I have set out, there is therefore absolutely no foundation for any of the subsequent criminal allegations that you have been made, and I will be directing that this incident report is filed as no crime. Well, of course, just to complete this list of skullduggery and lies, of course, the main thing that Mr. Toms was supposed to be investigating was whether Judge Horton lied about being told there were photographs, which is the key issue, that set the ball rolling in terms of Judge Horton's collusion. The reason why he's saying there's no evidence, because the only evidence that mattered was the recording, and he didn't seize the recording of the proceedings before Horton. I have little doubt, given what I have read to date, that your response to this will be to seek to lay complaint against me as being a further person who is seeking to wrong you by not agreeing with your version of events. It appears quite obvious to me that there is a very unusual and quite stark difference of perspective at play here, and I know this is not an isolated incident. I am fully aware of a very similar allegation you made against another driver more recently that has now led to proceedings against you for misuse of the 999 emergency system. There are also a significant number of other incidents reported that bear similar hallmarks in respect of your perspective of the world around you. So this is where we get back to the psychological psychobabble that is being resorted to at the last moment. Of course, I'm a complete Looney Tunes, and apart from glaring evidence of on footage and of injuries and so forth, it's all in my head effectively. And he's talking as though he's a judge. This is how judges talk, in this kind of long-winded and psychobabbly way. At this time, your current course of conduct towards the police and other state organisations is diverting scant resources at a time of ongoing financial pressure. It seems highly likely that if this ongoing behaviour is not addressed by yourself, it will continue to lead to consideration of further proceedings against you in order to help provide remedy. Well, on the one hand, those proceedings were at play years ago, because the police have paid over £100,000 of taxpayers' money because they're saying I'm wasting too much resources by litigating the police at all. So they've already got their lawyers, Robert Talalay from 5 court chambers, or 5 Essex chambers. Sorry, he's earned about £70,000 of public money to stop me litigating, and what's his name? Mark Leigh Morgan, who's a barrister from Sergeants' Inn Chambers. He's got himself another £100,000 or so fighting civil proceedings I brought against the police, mainly with Judge Cotter in his pocket, which includes the £25,000 that he earned from defending the case that I won in terms of the arrest on the 29th of April 2010, which I've referred to, which Vokins was involved with and effectively found to have colluded in that respect. So, and of course, when they pursue me, they then, as we shall see, and of course, as I say, why I say it's come full circle is because Stuart Toms was the one who oversaw the malicious communication investigation involving his junior Tottle. So he was effectively giving orders to her because he was her sergeant. And so he's the one that is clearly this threat. The last paragraph of this letter, where he's saying other remedy shall be sought. Well, you can't do the civil proceedings remedy because they've done that. They've had the JCRO against me for 10 years or more before this letter was even written. So they're talking about other remedy, which effectively really means trying to kill you, or colluding in anybody that wants to take a pot shot at you. And where that fails, if you react in the slightest way, even write a letter in one instance to Travis Baldwin, will trump up a charge against you. And of course, they spent about 100,000, or I don't know how many it was. I keep jumping at figures because it's impossible to include the amount of time I was on remand and the criminal proceedings in terms of perverting justice. And then when the perverting justice, in terms of my email to Baldwin collapsed, They then carried on with the criminal proceedings because that had been adjourned. The malicious communication proceedings had been adjourned to make way for the perverting justice, because that was a more serious allegation. And then the judge who dismissed the case, this is unbelievable. So you couldn't make this stuff up. The judge who dismissed the case, and I forget his name, I think it was Judge Parry, but I may be wrong, who dismissed the case on the 4th of February 2019 when the perverting justice case collapsed. In which because Stuart Toms hadn't turned up to the hearing, having spearheaded the prosecution against me, he's now, as I say, he's now Inspector Stuart Toms. So he's been promoted from the skullduggery, as I don't want to rehash that. Because he didn't turn up, the case collapsed, and the judge said, well, the time I'd spent on remand waiting for the trial for the perverting justice, the remand that had been imposed by Judge Tracy Lloyd-Clarke, who'd effectively given me 2 more months on remand than the convicted rapist who'd raped a 14-year-old girl got when he was convicted. And they still pursued me for the malicious communications, even though I'd done time. I'd already served whatever sentence I could have possibly got, even if convicted, so I couldn't have got prison. That was upheld by, as I say, by District Judge Harms. I forget even the dates now, but after at some point later on in 2000 where are we now? 2019. And then either 2019, 2020, I'll find the date, I'll put up on the screen when I make this ready for YouTube uploading. But at some point, quite a few months after I was convicted by Judge Harms in the Crown Court, in the Magistrates Court, Judge Harms, having heard all the perjury from Wasiak and seen the film footage, and the perjury statement from Wasiak, he still convicted me for the malicious communications. It was then several months later thrown out when I appealed it to the Crown Court by the Crown Court judge at the Cardiff Court, who said that there was no evidence that the call was malicious, that the 99 calls were other than motivated to get an investigation into the attack from Wasiak. So that and then they were all. I obviously didn't have to pay costs, and so all the proceedings together, for the time I did on remand, the trial and retrial of the magistrates and then the Crown Court, the investigation into all the original matters concerning Wasiak must have run into 50,000. I mean, somewhere between 30 and 50,000 pounds, I would estimate, but possibly a lot more. And because it doesn't obviously, but this is all effectively from Stuart Toms' threat, making good his threat, because he didn't mention. He said, "All right." He says he's aware. This is what he casually says. He says he's fully aware of a very similar allegation. Well, he's fully aware because at the time he wrote this letter to me, he was already overseeing the investigation for me in terms of that the 999 hoax call, which wasn't a hoax call at all, and these are the proceedings that he was talking about in terms of that matter. To conclude, just sort of by the way, if you're still with me, I've got a letter here from dated the 7th of November 2018 from somebody called Richard Graham. Now, Richard Graham was one of the solicitors who was appointed to me for 3 cases that involved that were being prosecuted for me in around 2018, 2019, and this, of course, included the perverting justice allegation from the email that was predicated on my email to Mr. Travis Baldwin. And of course, I don't need to undermine. There's nothing suggestive of in my email to Baldwin that I'm expecting to change his evidence. I'm simply saying that I'm giving him the opportunity to indicate what was clearly the case anyway, that he was leaned on in some way to give a false account, a ludicrously, laughably false account of what of our exchanges, by omitting the key evidence that I complained about Wasiak trying to kill me, and then saying I was over the top without any explanation as to what I'd done that was over the top, just as I said in my letter. But of course I would have been obliged to, what was I supposed to do, not report him to the police if there was evidence that he'd simply made this fabrication up on his own steam. bearing in mind all the other fabrications that the police had already colluded into before they even spoke to Baldwin, or certainly brought the charges against me for perverting justice. But so all this material would have been with Richard Graham, because Richard Graham was the only solicitor that I could get to act for me, whilst I'd been rotting in prison indeed I was already in prison on another trumped up charge concerning a breach of a civil injunction, and I'm not going to go into all that because that would obviously keep us here for another 4 or 5 hours. And hopefully you've kind of got, if you're not with me so far, you'll never will be, in terms of my persuading you that there is a judicially led conspiracy against me to shut me up and to come what may, and whoever gets in the way of that objective are victims, including the wider public and including obviously any innocent bystanders in such as Baldwin, who's just another poor innocent bystander, effectively, in terms of the armed attacks against me that continue apace. So I managed to get the solicitor, and he was eventually found by the what was called the legal ombudsman, who investigate poor service by solicitors. And it was found that he had provided me poor service in order to pay a couple of £100 compensation for that. And this is just sort of icing on the cake, as it were, in terms of corruption. But he wrote to me on the 7th of November 2018. And this was mainly in regards to the fact that I'd sacked him by now. And he says, as you shall see in a moment, he talks about me not sacking him at some point in the future, but I'd already sacked him. But he'd agreed to attend a hearing, I think on the 3rd of November. Yes, the 3rd of November 18, which was arranged for an application to dismiss the perverting justice, because the original, and of course why I put Miss Barrister from Queen's Square Chambers, she's a Catherine Flint. She was the original barrister that was effectively appointed by the court, although she'd gone through some freelance solicitor. I can't remember all the details, but I sacked her straight off the bat because I didn't want any barrister connected to Bristol, given the history that I have with the Bristol Judiciary, including a conviction for falsely imprisoning a barrister from Albion Chambers, just around the corner from Queen Square Chambers, and of course all my general complaint that the judges in Bristol are as corrupt as the day is long, and have it in for me without any, nobody can dispute that, having seen any of my videos on this subject. I engaged with her a bit about getting the case transferred and about her general appointment, and sacked her quite shortly thereafter. But she obviously had all this material, so this is why I'm focusing her in terms of my exposés and campaigns to doorstep and hold these people to account, including Miss Flint. So she would have had all this unused material, all the video, the CCTV of Sabruz Latty's dangerous driving, his perjured statement, the perjury from Wasiak, the perjury from Toms, the threatening letter from Toms, indeed, that he's going to come after me for wasting court time. The way to come after me is to do me for perverting justice by making false allegations. But I have never been charged, never been formally accused, never been interrogated for making false allegations. That is the only way to shut me up. So, the correct course, if I was making false allegations, either in terms of the initial dangerous driving, which of course I'm not because the police accept that they've occurred. So if I'm making false allegations in terms of evidence of cover-up, and that in fact the police officers I'm accusing, whether it's Ben Vokins or Dennis Green or Denny Green or however that's pronounced, or Judge Horton indeed, or the CPS solicitor Kenneth Bell, or whoever I'm accusing of saying there's glaring evidence that I was the victim of far more serious dangerous driving than has actually occurred. And of course, in the case of Latty, there's an independent witness and there's CCTV that the police themselves provided. So it's in that case, it's more to do with collusion. But of course, we've had the absolutely ridiculously perjured statement from Latty. Then obviously, if there was evidence that I was making these false allegations, especially repeatedly and at a huge public expense, as Toms complains about, then the way to prosecute me, or the charge that I should be pursued for, is perverting justice by making false allegations. It's here on the screen. It's a common law offence that everybody's familiar with that's had any even tiny bit of interest in the criminal justice system. Everybody knows that it's very bad to lie and certainly to make false allegations that somebody has committed offences when you know that person hasn't committed an offence, or in my case has actually been the victim of violent offences. Then and obviously I've never even been investigated for such charges, but that would be the relevant charge to pursue me under if what Toms is saying is correct. But of course he knows full well that there has been cover-up, that Toms is as corrupt as Horton, who is as corrupt as Dennis and Dennis Green and Vokins, and the CPS crony Kenneth Bell, and on and on. And of course, if you go to my other videos, it's just repetition of the kind of complaints I've made in respect to this instance. But what he's actually so he's clearly not threatening me with perverting justice, which he should have been pursuing me for in the first place. Even in terms of my complaint against Horton and Kenneth Bell and Vokins and Green, let alone in terms of what's gone on with Uslati. And we've seen the statement from Wasiak, where Wasiak says that the CCTV disproved my version of events. Of course, as I've already repeated, he doesn't indicate what the version was or what the CCTV showed. But again, Wasiak is accusing me of perverting justice. Again, Toms would have had knowledge of that because he would have had all the unused material, all the material related to the investigation that was initially carried out by Carpenter with Wasiak's involvement. And it was Wasiak who decided to file it on the basis that I was effectively lying about what had occurred. So he would have been aware of all that. So he would have had ample, if what he is saying is true, that I'm just simply making these false allegations and wasting police resources and public resources as a consequence of that, then why not pursue me for perverting justice? And of course, as I say, he knows that they can be fully substantiated, my allegations, and that it's him that's perverting justice. It's Horton that's perverting justice. It's Wasiak that's perverting justice, and not myself. So the threat, in terms of the further proceedings, is clearly to do with malicious prosecutions. That's what he's really talking about, and malicious prosecutions that are predicated on glaring evidence that somebody has tried to kill me or nearly killed me with a deadly weapon, such as a large vehicle that weighs however many hundreds of tons, that is gunning at me. Whether or not the actual driving itself is deliberately, if there's actually some premeditated, that somebody's got on their mobile phone and said Ben Gray's coming down the road, I accept that's highly unlikely. But it's simply that there's so much dangerous driving in Bristol anyway, and maybe that I've got a face now that people recognise. That there's all manner of scenarios in a dangerous place like East Bristol, East sort of Central East Bristol, which has a reputation of being that kind of place. Then he's going to jump on and seize upon any situation whereby somebody has, for whatever reason, nearly killed me in a vehicle, to trump up a prosecution. And of course, he knows he's got he's not only got the CPS in his pocket, but he's got the judges in his pocket. Judge Horton, who's already, as I've already established, been hauled over the coals for being corrupt in terms of using his position of power trust. He's obviously the last judge that should be. He shouldn't even be on the bench, obviously, considering his history. But they know that with him in his pocket, who's even making decisions about what he claims to have seen me about my behaviour allegedly when he's been strolling around, with his umbrella out on Small Street, which is just outside Bristol Crown Court, and so forth. So he's not only so this threat is already being made good with the malicious prosecution, which is what it actually is for the malicious communication charge. But he's also they're now seizing upon the email that I sent to Baldwin as evidence that I've tried to pervert justice or get him to change his testimony. And I was arrested, as Toms himself makes clear in a witness statement dated the 25th of June, so several months after he's written to me in February 2018. And Toms provides the following witness statement. I am Detective Sergeant 275 Toms of the Avon Somerset Constabulary, currently based at Bristol Criminal Investigation Department. At 19:30 on Saturday, 23rd of June 2018, I attended 6 Boswell Street. So what he means by attended is knock on the door, you're under arrest. Bristol with DC Tottle and PC Morgan when the door to that address was answered by a man I now know to be Benjamin Gray. After introducing myself, I said to Gray, I am arresting you on suspicion of witness intimidation in respect to an email you sent to Travis Baldwin on the 5th of June. Quotation marks. I cautioned him and he replied, he's a defence witness, he's a defence witness, he's not a prosecution witness, he's a defence witness. I can't be intimidating a defence witness, can I? He's unused material. Do you know about the law? Mr. Gray was allowed to gather some belongings before being transported to Patchway Custody Unit by PC Morgan and DC Tottle. I then booked Mr. Gray into custody. Throughout this period, Mr. Gray continued to complain about being arrested and that I and DC Tottle were involved in this due to our previous involvement with him and his complaints regarding this. At 22:51 that same day, I and DC Tottle commenced a visual and audio recorded interview with Mr. Gray. This interview was brought to an end by me at 23:42 that day, as Mr. Gray had made it clear he did not intend to allow me to continue to speak further by talking over me. The police reference for this interview is whatever it is. He was subsequently released from custody on condition of bail. And in due course, I was indicted, as the indictment will come up on your screen, for perverting public justice by attempting to get Mr. Baldwin to change his testimony, which of course I never did. And even if I had done so, it was a minor infraction. And of course, I was unrepresented, so I wouldn't have, I was simply doing what I thought was relevant in terms of necessary in terms of my counter allegations that Baldwin, as he clearly had been coerced, presumably by Tottle, or certainly or Toms, or both, or certainly colleagues of theirs when they took the statement from Baldwin. But of course, whatever misconduct I was alleged of carrying out, and of course the case against me collapsed, as I've already pointed out. The CPS offered no evidence at trial. That's really the history of those shenanigans. As I say, at huge public expense, untold evidence of perjury, perverting justice, in which Toms was colluded, and Toms even was just blasé and writing a letter threatening that clearly saying, I'm going to be abusing my position of power and trust to persecute you because you've been sort of trying to pick at the scab of this ridiculous and just endless corruption that is centered around people who have made armed attacks against you, that's just one element of the endless corruption that I'm referring to. Meanwhile, whilst I was being prosecuted for the perverting justice and the malicious communication charges, which were clearly connected, because once I was pursued for the perverting justice, both the cases, as I think I've already mentioned, was transferred to the Crown Court for the proceedings to unfold there. Then, when the case collapsed on the 4th of February 2019, as I say, the malicious communication charge was then transferred back to the Magistrates Court, where it originated from, in Cardiff. And as I've already said, I pursued I defended the case, and the District Judge Harms convicted me, and then I appealed that, and I think in July or June of 2019, the judge to whom I appealed said that there was no case to answer and there was no evidence of that my calls were maliciously motivated, but they were motivated on a justified complaint of dangerous driving, but of course, by the time the judge had even though I didn't have to give evidence, he'd already seen the notes about my calls being treated as hoax calls within 24 hours of my making the calls. Almost immediately, were treated as hoax calls, which was glaring evidence of perverting justice in its own right. Especially as the judge's own findings were that my calls had been justified, therefore providing further conclusive evidence from his own mouth that the treating my calls as hoax was clearly completely fabricated and was colluding in the effectively colluding in the threats to kill being made by Uslati. And I should just mention, of course, with the interview with Tottle and Toms. one of the key issues was my complaint that there had been dangerous driving and that the police were colluding in that. I think it's Tom's sort of vaguely alludes to that when I'm complaining about him, and I would have made that clear. But of course, he's missed out of the statement. But clearly, if there was dangerous driving and there was evidence that Toms and Tottle were colluding in that, and one of the issues that came up and so we started quarrelling about when the interview was ended by Toms was the availability of the footage. By now, the incident is nearly a year old, and I still haven't received the CCTV. It's been looked at. Wasiak has discontinued the investigation in October of the previous year, and I've made an access freedom of information request. I should have been entitled to the video once I was pursued for the malicious communication, because it was obviously, I could already argue that the case was an abusive process, or the proceedings were an abusive process, because it was predicated on glaring evidence that somebody had tried to kill me. And of course that impacted on the statement that the ludicrous testimony and clearly fabricated testimony from Baldwin, which had omitted the fact that I complained about Uslati trying to kill me. So on the one hand, if I'd fabricated the attempt to kill, even if I had done that, Baldwin didn't know that. He said he wasn't aware of the earlier part of the incident. So all he knows is that I've complained about somebody tried to kill me, and then he said I'm acting over the top and thought I had mental health issues for no apparent reason. He doesn't give any indication. He says I mentioned Allahu Akbar, but that was clearly, again, it's out of context of my saying that the man had made threats to kill and appeared to carry out a terrorist attack against me. And once it became clear that he was Middle Eastern, although I didn't know, you couldn't tell that he was Middle Eastern from immediate first appearance. And then secondly, clearly, if Baldwin, this is on the basis that the Baldwin didn't know whether the dangerous driving had occurred at all, but clearly the CCTV proved that it had been deliberate. So and had actually happened in terms of, as I relayed it, that he nearly tried to kill me twice, because first of all he tried to drive into me as I was cycling past, and then when I went round the back of his vehicle to stop him and to ensure that he didn't drive into me, he then reversed into me, which is when I used the bike lock. So there's no mention in the statement. So he's clearly perverting justice. He's concealing the commission of an offence. He's trying to fabricate. He's trying to make me to be the culprit for being over the top and expressing mental health issues by omitting the fact that my main concern was the attempt on my life by Uslati. And of course, the CCTV was therefore pivotal to proving, why his statement was clearly fabricated, and my efforts to try and find out why it was fabricated, which was clearly because Toms and gang are so corrupt that they pressured him, or they either pressured him or he never made the statement. Of course, we never got testimony because the case collapsed, so he didn't give evidence against me in Cardiff Crown Court. So he may not have ever even made the statement. It could have been, signed off by any Tom, Dick, or Harry. It was quite clear that it was never going to go to full trial. That the trial was just simply an excuse to remand me and terrorise me further. And of course, Tom's even got a promotion out of it because of the modus operandi of the corrupt police and CPS is to promote anybody that's the more corrupt they are, the higher up the rank they go, whether they're judge, barrister, or police officer. But so we draw a line under that, and there's of course the issue of legal representation. So there's the issue of legal representation because, as I've established in other videos, and is hopefully quite clear from the general details of this documentary, I cannot get representation anywhere on the Western Circuit. Western Circuit is from everywhere from Bristol down to Exeter, and I think even as far as Cornwall. No firm will represent me. I mean, one of the reasons is I've got a conviction for false imprisonment of an Edward Hetherington, who's a barrister from the Albion Chambers. I've got a restraining order not to contact two other barristers from Albion Chambers, David Chidgey and Paul Cook. Well, Paul Cook is now a fully fledged circuit judge. And of course all the firms, because Albion Chambers are the big honcho, main barrister chambers for the Western Circuit, and especially in Bristol and Cardiff, where the case had been transferred. So the transferring of the case at all was in order for me to was partly facilitated and ordered by Mr. Justice Dingemans, who's now I think a Lord Justice. So again with the promotions, Lord Justice Dingeman, or at the time Mr. Justice Dingeman, agreed with the CPS, who agreed with me that the case should be transferred to London at a hearing somewhere around 2018, and. But once that was agreed in open court, the case immediately went to Cardiff, which wasn't agreed, which simply was full of Albion chambers, and therefore created the same problem in terms of my getting legal representation, or preventing getting legal representation. So I got in touch with a John Melody, apparently on the 8th of August 2018, who was made aware of these charges against me, and he's he was a solicitor from MK Law, and MK Law is outside of Bristol, and I think it's centred in London. So, that was obviously the first step in ensuring some sort of independent representation. But of course, they had to get a barrister because the matter's going to Crown Court, and they just appointed this female barrister called Catherine Flint, who's from Queen's Square Chambers in central Bristol. So I'm straight back to square one. There's glaring conflict of interest because Catherine Flint, who was a fairly junior barrister, who was just starting out, fresh-faced and all that, she was already, she liaised with, if not friends with, Albion Chambers barristers, the ones that I've got restraining orders against. And of course, she's going to any conflict of interest in terms of my allegations about Judge Horton, which was of course relevant because all of this is, Toms himself has made no bones about his conflict of interest, and that his threats to to make these proceedings were Toms making good his threats when he was investigating Horton. So clearly Horton was at that time still sitting as a judge, and Catherine Flint was of course still attending Bristol Crown Court mainly. That was her venue, so she would be making representations to Horton, and would obviously be far more interested in sucking up to Judge Horton than she would somebody called Ben Gray, who's on the dole, who's making all kinds of very serious allegations of judicial corruption. So I was back to square one. I might as well have just stayed in Bristol, had the case stay in Bristol, because then the only good that having it in Cardiff was for anybody was for the CPS, because it meant that I had to travel 3 hours there and back, spend loads of benefit money to get to Cardiff, and be exhausted by the time I've actually got the hearings underway at sort of 10:30. I've already been up 5 hours, and I've got to relive being run over and driven at and all this perjury stuff, whether or not I'm representing myself. It was, and clearly whatever good Flint was to me, she clearly she didn't agree that the case should be. She was refusing to make representations. The first discussion I had with her is about getting the case transferred to London, which was already agreed months before in front of a High Court judge. And she said no, it's going to stay in her opinion, it should stay in Cardiff. So she's already acting in the interests of the CPS. They want it in Cardiff because it's packed with Albion Chambers cronies, as we can see from the decisions that they made, and obviously it's exhausting and time consuming and so forth, and in terms of for me to get to Cardiff, and then takes a chunk out of my energy and my ability to focus and stay on my feet when the trial starts. And I should mention there were two trials, and I'm not going to go into the details of the other trial because obviously, that would just make things far too complicated. So the further discussion was about whether the case was an abuse of process, or whether, as Catherine Flint had formed the view, that the proceedings should be for perverting justice. I think not the malicious communication charge, but she said that she would make an application to dismiss, which has to occur before somebody's pleaded guilty or not guilty to the charges. And in due course, I raised this matter. I raised the two issues that I had with Flint. I sacked her, obviously, sometime shortly after my meeting with her at a hearing at the Bristol Magistrates, sorry, the Cardiff Magistrates Court, where we'd had this discussion about transfer and my concerns about her being appointed at all, because it was clearly against my interest for her to have a local barrister, considering everything that I've just mentioned, and whether or not the case should be, whether she should be making an abusive process application rather than an application to dismiss. And this was all raised with Stephen Freeman, who's her senior colleague at Queen's Square Chambers. It's not entirely clear whether he himself is actually a barrister, and I'll probably get that out in due course before this video and put a little note up before this video is released. But he raises the issue of, that I had raised with Catherine Flint about abusive process, because obviously I'm saying the case is completely corrupt from start to finish, because I was the victim of dangerous driving. I'm the victim of endless perjury from everyone from Toms to Wasiak to Wasiak, Mr. Freeman investigated these various complaints about Catherine Flint, and he responded at paragraph 5 of a letter or. So this is an email I received from Stephen Freeman, who is Catherine Flint's senior colleague at Queen Square Chambers, and he investigates any complaints against other barristers in the chambers. And he addressed the two issues that I'd raised, several issues I raised, but the two main issues in terms of Catherine Flint's appointment was obviously that she should never have been appointed to two. Well, the three issues: she should never have been appointed because she was obviously local and therefore had a conflict of interest. She refused to agree with my issue about transferring it to London rather than remaining in Cardiff, which, as I've already said, is packed with Albion Chambers, and I've got injunctions, restraining orders in terms of contacting them, and so on and so forth. And the third issue, perhaps most, which covers all the issues really, is whether it was an abusive process application that needed to be made or an application to dismiss. An application to dismiss is generally that there isn't enough evidence to continue with an indictable charge. And a barrister, if you're represented or if you're in person, if you can get a word in edgeways, you make an application to the judge there's simply not enough evidence to put before a jury, and the case should be dismissed before the person even has to plead. And that was Catherine Flint's view. She obviously, it was a little bit in my favour that she agreed that the case against me was not substantiated and that there was grounds to have it dismissed per se. But my complaint was that it was illegal. That it was the concern for the CPS and for her was the extent of perjury, perverting justice, collusion in the armed assault from Islati, which effectively armed assault, but dangerous driving, if you like. It's still a very serious offence. And from Wasiak, and obviously all of this was clearly just simply Toms making good his threats in terms of further proceedings and abusing his position of power and trust, together with the CPS, to persecute me for exposing Judge Horton and all the other officers that are mentioned in these documentaries, including, of course, Green and Vokins, etc., for the corrupt and evil abusers of office they are. So obviously, with the statement from Wasiak, the statement from Islati, the evidence from the CCTV camera, the independent witness of Truslow, you couldn't found do me for a relatively, completely nefarious claim that I perverted justice by writing an email asking why that they changed their testimony so much from the truth, and obviously pointing out that I would have to report them if it was evident that they were doing that off their own volition rather than from police coercion, which in my view was clearly the case. But in any event, that was as nothing compared to the extent of perverting justice, collusion, and effectively attempting murder, and all the other things that I mentioned earlier in the documentary. And so we have the official position from Queen Square Chambers as set out in the email of the 30th of August 22 from Stephen Freeman. So he says, in paragraph 5 of his correspondence, I'll read out paragraph 5. He said, CF, which is obviously Catherine Flint, recalls meeting you at the Magistrates Court on the 9th of August 2018 and having a substantial conference with you before the case was called on. Having considered the evidence and discussed it with you, she advised that the most appropriate course would be to make an application to dismiss once the matter had been transferred to the Crown Court. As the charge was indictable only matter, you would not have been expected to enter any plea at that stage. So in CF's opinion, there was little to be done until such time as the case had been transferred. You, however, wish to pursue an abusive process argument, and CF says that you appeared somewhat aggrieved that an application to dismiss was being recommended as opposed to the abuse argument. So far, so true. That's exactly the issue that I had with Catherine Flint. For her part, says Freeman, CF says that she explained her reasoning to you, i.e. that there simply was no identifiable abuse upon which such an argument could be founded. It subsequently transpired that you withdrew your instructions from each of your legal representatives and went on to represent yourself. What he doesn't mention, of course, he might mention somewhere else in the email, but so he doesn't mention the fact that I was right on. Well, I was certainly the fact that I was acquitted on both charges is obviously indication that there was something deeply wrong with the prosecution to start off with, given that I was unrepresenting myself and I was in the worst possible, next to Bristol Crown Court, I was in the worst possible court in England, considering it was stuffed with Albion Chambers barristers and judges, all of whom, with whom I have a very serious history, including a conviction for false imprisonment of a Albion Chambers barrister. But in any event, so the abuse versus the application to dismiss. Again, no details. You see, this is. You can see how this just goes on and on and on. Anybody in authority who's giving decisions, making absolutely fundamental decisions about how a case should be dealt with, whether I should be charged or somebody else should be charged or somebody else should be investigated, it's simply completely arbitrary. There's no reasoning, no rationale, no reference to the evidence, no reference to the substance ever mentioned, whether it's Wasiak, whether it's Toms, whether it's Freeman. So it's completely arbitrary, and obviously they can't mention the evidence because the evidence just simply proves, as soon as they get anywhere near mention of the evidence, it immediately proves everything that I'm saying. Abusive process is when is an authority under R.V. Maxwell, which is long-standing, and it's basically it originates or is mainly concerned with police officers who go undercover and have to therefore commit offences in order to inveigle their way into various gangs and groups and organisations. There's a famous case where a police officer, I'll try and get his name to put it up on the screen, when this video is completed, who I think inseminated one or two females, or one female twice, or something, had children as part of his undercover guise as a CID investigating officer. And clearly, that can't be lawful in terms of misrepresenting himself to the extent that he built this relationship up with this female. And of course, it can often include violence, it can include drug deals, and of course, the horrors that went on in the Troubles in Ireland. There's a lot of the grasses or the informants for the loyalist troops, for the loyalist police force, for the Ulster Constabulary and so forth, were themselves killing terrorists on behalf of the IRA. So the extent to which criminality is allowed by the authorities in order to get further criminality or further case against the people they're investigating is, of course, a thin blue line by any criteria. And obviously, the court has long since ruled that any evidence that the whole system is being undermined by some sort of abuse of power or criminality is not acceptable, unless, of course, the matter that's being investigated is far more serious than the criminal offences that are being committed by the undercover officer or by the officer in question. I think there's also the R.B. Maxwell was about a somebody being kidnapped from another country in order to bring them back to the UK, and the extent of which the criminality surrounding their being kidnapped was undermined the legality of the proceedings that they were being kidnapped for. But in my case, of course, there were, the perverting justice on the sort of scale that I was being accused of is, a few months in prison, if that. Assuming that I was guilty at all. But of course, they can't predicate that whole charge on the basis, especially on the glaring evidence that Baldwin had been coerced, that he had changed his story, that it would have been ridiculous that he would have given this account, and the police would have just casually written down this account when my 999 call in front of Baldwin had been that somebody had tried to knock me off my bike and nearly killed me, and he missed that out and then said that I was acting over the top. So there was clearly a conspiracy from the police, and they should have pursued Baldwin themselves. If Baldwin had simply made this allegation up, then the investigating officer that took the statement from Baldwin should have said, well, hang on, I mean, he's saying over the top, but wasn't he nearly killed sort of 10 minutes earlier? And wouldn't that sort of explain why he was being upset? And what exactly is Baldwin saying about my over-the-top behaviour? Sort of implying that I've just shouted Allahu Akbar as though I'm the one who's spontaneously shouting Allahu Akbar. I mean, it is comical in terms of this is one of the side issues of this kind of corruption. It actually becomes quite humorous because it's straight out of a Monty Python type of sketch, where it's simply surreal, the extent of corruption that's involved. Because, as I say, the Allahu Akbar, as was made clear, I think I made it clear on the 999 call, and I might be able to include it in, pause it now. I'm going to pause now in case I can find it, and then I'll play it, and then there'll be no doubt about it. But it's certainly on the record about the near-death experience from the dangerous driving. And of course we've got the statement from Wasiak, which was clearly perjured, and the CCTV and so on and so forth. So on what basis can Catherine Flint be saying that there was no abusive process? The only basis is that she is as corrupt as Wasiak, as Toms, as Horton, as Dennis Green, and all the others individuals that I've made in the rest of the documentary. That she's up to her neck in this near threat, and she's obviously well aware that anybody that colludes in this sickening trail of blood and horror and complete lies and perverting justice and misconduct in public office gets a promotion. She's thinking, if I get Ben Gray stitched up, or get him, or simply collude and not permit this case to go, certainly not to permit, which is obviously what I'm interested in doing, hence this documentary, and was at the time, of getting a counter investigation and getting everyone involved in this conspiracy, which includes Judge Tracy Lloyd-Clarke, this woman who was happy to have me banged up, and all this was in front of Tracy Lloyd-Clarke when she refused me bail in, I think, October 2018, and kept me on bail, kept me remanded rather, until the case collapsed in February 2019. But meanwhile, she's quite happy to give only 2 months to her convicted rapist, who's actually pleaded guilty to raping a 14-year-old child, and is going to be out of prison in a month. So I had to do twice as long, when I was glaringly the victim of every kind of offence under the sun, including attempted murder, as far as I can see from the CCTV. And so Flint is clearly well-minded to think that if she whatever happens, she doesn't get the counter allegation, which would have been her obligation, because there would have been an abusive process. If the abuse was agreed on the terms, or anything like the terms that I've set out in terms of the CPS colluding in the perjury, perverting CPS and police colluding in the perjury, perverting justice, attempted murder, perjury from Uslati, and so forth, then of course I'd had a much better chance of doing that if Flint had agreed with me on the abuse, and then that things would have flowed on from that. But she's saying there's no abuse. But of course, what she isn't saying, and what Flint isn't providing, when Freeman, in his response, when he says that she explained her reasoning to you, she didn't. That in itself is a lie. There was no reasoning, because the reasoning would have been based on forensic details about the evidence that was being relied on by the CPS, or not relied on, but disclosed as part of unused material, which would have been relied on for me to prove the whole thing was a stitch up to shut me up. And of course, overarching the all of the abuse is the fact that the investigating officer, of all the police officers I get to investigate the matter, it's Toms who's actually made it clear in terms months before I'm pursued for perverting justice that he's going to get me because I'm making these other criminal allegations that he says aren't substantiated. So, very finally, in terms of legal representation and this documentary generally, is the next lawyer, solicitor I tried to obtain, and this was a man called Richard Graham. And Richard Graham was in due course ordered by the legal ombudsman to pay £250 compensation for poor service, when he agreed to represent me on 3 separate charges. There was appeal against the matter that I mentioned. There were 2 matters when I was before Cardiff Crown Court, and he agreed to represent me on that one, on the perverting justice, malicious communication. And there was yet another charge, which is obviously going to be the matter for another documentary in terms of reckless assault of a PC, Sam Smith, when he's actually torturing me, and he says that because I'm shouting at him about him torturing me, some spittle landed on him, and I was done for spitting at him in terms of reckless assault, and that went before. Eventually, I appealed that, but I couldn't go to trial because I was then done for because I couldn't go to Reading Crown Court where the trial was pursued. I was before a judge, Dugdale, who's from 2 KBW chambers, and as you can see from my documentaries, in other documentaries, 2 KBW chambers have taken over from Albion chambers as to be the chambers that have all the axe to grind, or the horse in the race. So Graham has agreed to represent me. But within fairly short order, I had to sack him as well, because not least he's what's called I mentioned Kenneth Bell for the CPS. He's a solicitor advocate, which means that he's not actually a fully fledged barrister, but he has rights of audience and can effectively act for his clients as if he's a barrister, and can make representations to juries and judges. And he agreed to represent me. And there was a hearing on the 3rd of November that was ordered by Judge Tracy Lloyd-Clarke, which was going to be the hearing for the application to dismiss. I can't quite figure out why I didn't pursue the abusive process, or whether the abusive process was heard by Tracy Lloyd-Smith. It's all quite confusing, because obviously I was in custody at the time, and I was remanded because of Tracy Lloyd-Clarke's ruling. And so on and so forth. So but certainly Catherine Flint had set in motion an application to dismiss, ignoring my obviously insistence that it was actually abusive process and should have been heard as soon as possible, because obviously if it's an illegal prosecution, then it shouldn't be allowed to continue for any length of time. Especially shouldn't be allowed to have me remanded until that issue is heard. So taking over from Catherine Flint was Richard Graham. And Richard Graham, as I will make clear in the letter, tried to get a barrister, and I'd spoken to him on the phone just a day or 2 before the 3rd of November hearing, 2018, and he said, well, if I can't find a barrister, I will attend, because I'm a barrister, and I'm not a barrister, but I have rights of audience, and I can represent you before the judge. He wrote a letter to me after I had actually sacked him, so this letter was a bit confusing from his point of view, because he still seems to think that he's representing me. But anyway, I'll read the letter out. I write to you, this is dated the 7th of November 2018. Read your letter dated the 3rd of November 2018. I write in order to give you an update in relation to what is happening with your matter. As you are aware, we had considerable difficulty in instructing a barrister to represent you before the Cardiff Crown Court. This matter was adjourned until the 13th of November 2018 in order for us to make an application to have the matter moved to London. I know that this matter was already moved from Bristol Crown Court, and it is very difficult for us to find representation for you. When I say difficult, what I mean is that we have contacted every set of barristers' chambers and freelance solicitor advocates that would attend and represent you. This has been unsuccessful. The fee for perverting the course of justice matter is very low based on the classification of offences. This means that it would not be economically viable for me to travel all the way from Herne Bay to Cardiff to represent you, although this was to be my intention. If the court decide that your matter will stay in Cardiff, then I will personally travel to Cardiff Crown Court and represent you. In respect of your matters before the Bristol Magistrates Court, we have obtained permission from the court to deal with these matters via video link in order for you to enter your pleas in respect to the 4 assault matters. I will also attend video link and hopefully will find someone to represent you nearer that day. In the event that we are unable to find someone to represent you, then again I will travel to Bristol to represent you on that occasion. This is very unusual. Normally I can find a barrister to go anywhere, but for some reason it would appear that no one on that side of the country is willing to represent you. Hopefully we can have your matters moved to a London court, and therefore hopefully I should be able to find a suitably qualified barrister to represent you. I note from your letters you are dissatisfied with the service you have received. Well, actually I've sacked him, so this is all completely for the birds anyway, because I'm not going to go back on sacking him. I can assure you that I am personally doing everything I can to try and sort you out representation before the Crown Court. I note that you are threatening to dismiss my firm. I would ask you not to do that because we are genuinely trying our very best to help you out in a very difficult circumstance. I note that you are really struggling with getting representation. We are hundreds of miles away from where you are, and I'm still prepared to do everything I can to help you out because I believe in justice and I believe that you deserve to be represented. If, however, you are absolutely certain you no longer want me to represent you, then please let me know and I will close your file. Well, I mean, this is just utter gibberish as usual from in exactly the same vein as Mr. Freeman's letter was in terms of Catherine Flint. Of course, again, nothing to do with substance, nothing to do. He's got 3 cases of mine. One is an appeal that was out of time anyway because he took so long in responding to that. So that was another reason for sacking him. And of course, he doesn't mention the fact that he failed to attend the hearing. He doesn't explain why. He said he agreed to attend the hearing in Cardiff for the 3rd of November, but he never showed up. And that's just, I'm supposed to ignore all that. And of course, even if he had turned up, we had no idea what representations he was going to make because we had not exchanged a single word about the substance of the perverting justice charge, or what Flint agreed was an application to dismiss, and I said was an abusive process. So, the only thing he says in my favour, which helps me to some extent, is that I can't. No barrister will represent me. So any charge, any allegation that's brought against me in the criminal courts is clearly illegal because I can prove that every single barrister across the UK is refusing to represent me. And a key issue that obviously was pivotal to my understanding and being able to progress that issue about representation was that no explanation is provided as to why, if Mr. Graham thinks it's unusual for barristers to refuse to represent me, why doesn't he ask the barristers that he says he works with regularly? So he's got these groups of chambers or these 1 or 2 or 3 chambers that this is how it works with the criminal justice system, that a solicitor will usually have 1 or several barrister chambers that they always use, and if they can't make availability, then they'll go elsewhere, but they usually have a partnership with various chambers. So he'll have these chambers that he's supposed to work alongside. They're refusing to act for him in my case, or refusing to act for me with him as my solicitor, without, apparently, according to Mr. Graham, providing any explanation. And I contacted him. I said, please, could you give me some indication of which chambers have refused to represent me? He refused to give me that information. Why haven't you sought any explanation as to why they're refusing to act for me? And of course, this, I'm absolutely certain he had no intention of doing anything for me absolutely whatsoever, and was probably almost certainly taking backhanders from the CPS. Who would just say, look, Judge Warby and a whole bunch of other judges have got the knife out for Mr. Gray. Don't go anywhere near him. He won't be able to do anything. He may make a complaint to the Law Society, and once in a while they do act honestly and find in the favour of the client. Very rarely, but they do it. They did in my case. But you won't be, and we'll make it worth your while just to leave to hang him out to dry in terms of representation. That you know, whether or not he did reach that agreement with the CPS, he certainly got a huge chunk of money from the legal aid for doing absolutely nothing. He did not a single shred. All he did was write this one letter and speak to me a few times on the phone. When I spoke to him on the phone, he was effing and blinding continually, which I found offensive. And I said, please don't swear on the phone. And you know, he talks like that. He's a bit right, a bit duck and dive and sort of way of talking. And I'm supposed to probably that worked. That's a good spiel for some of his clients, but it didn't cut much ice with me, and he was just a lying, corrupt, evil, another lying, corrupt, evil so and so. So I contacted the SRA to put pressure on to try and find out to complain that Mr. Graham is either lying, that he didn't contact any barrister chambers and therefore they weren't refusing to act for me, or he was withholding vital information for future representation issues in terms of the fact that no one would represent me in any proceedings. And therefore, the Article 6 Human Rights Act, which states that somebody who's charged with a criminal offence has an automatic right under the Human Rights Act to have legal representation that will be provided for them if in the interest of justice. And of course, where somebody's facing prison, then it's clearly in the interest of justice that somebody's represented, especially if the CPS themselves are represented. Clearly, I need that when I obviously, because if you go to my video "Barbarians at the Gate," you will see I was prosecuted in 2022 in front of Recorder Sellers with Judge Laurie, Ian Laurie, who oversaw those proceedings, and of course, you know, no one was going to represent me, and my rights to be represented were completely flouted. As you know, the only positive that's come out of Mr. Graham's involvement was the fact that he's provided complete evidence that if he can't get a barrister to represent me even from outside the Western Circuit, that any proceedings inside the Western Circuit, which of course is where as I say, the Barbarians at the Gate video surrounding my prosecution at in the Gloucester Crown Court, because that is very much in the Western Circuit. It's just down the road in terms of from the Bristol Crown Court. That such proceedings are de facto illegal because I cannot get representation anywhere in the Western Circuit, and no one will travel, as Mr. Graham makes clear, even from outside the Western Circuit. I mean, he says every barrister he's tried to get. We don't know how many he claims to have contacted, but of course. This is just the icing on the cake in terms of the extent of corruption and evil that I'm out to expose. So I conclude my documentary, Nothing to See Here, and I ask you to judge for yourself whether I, and therefore the public justice system, are the victim of these complete corrupt and evil wrongdoers. And of course, the threat to the public, if these people are allowed to go completely unaccountable, doesn't need spelling out. Welcome to my documentary, Nothing to See Here. This is another one of